Good morning, everybody. Happy Wednesday. Welcome to TCF Live. I am Dan Soul. I will guide you on this 3-hour journey through Courtlandia, starting with Magistrate Chisholm.
What is your name, please?
Emma Golkovich.
Emma Golkovich. Okay, you're in the right place. Your ticket is 26 R0 4410. You were ticketed on the 23rd of June, about 9:05 in the evening, in the area of Royal Oak near 13 Mile Road in Maine, for unnecessary use of horn. You can admit responsibility for this civil infraction. You can deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I would like to plead not guilty with an explanation.
Raise your right hand, please. Do you
I have
swear
my right
or
hand
affirm?
raised.
Ma'am, I'm asking you to take the oath. Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
The officer will testify first, please.
On June 23rd, 2026, at approximately 9:05 p.m., it's at the intersection of 13 Mile and Main. We were at a red light for eastbound traffic on 13 Mile. While waiting at the red light, pedestrians crossing Main from 13 Mile had the right of way. There was pedestrians in the crosswalk, and there's a car waiting to turn right while they had the right of way. At that point, I began to hear a audible horn from the white Ford Escape going off. When I looked over to my right, observed the white Ford Escape behind a vehicle who was in front waiting to turn right, but was waiting for the pedestrians to cross. When I looked at the driver had her hands raised, and it appeared as if she was yelling at the car in front of her, which it appeared that she was using her horn to honk at the car in front of her, although the car was waiting for pedestrians to cross.
Was this a single beat or was this a blast?
It was a prolonged blast.
Ms. Golkovich? It's your turn, ma'am. Would you tell me what happened?
I'm sorry. I didn't know I could proceed. I was going, I'm not really familiar with my Royal Oak roads, but I was driving down the road. The vehicle in front of me, I used my horn, and I was raising my hands. I take full accountability for honking my horn. I did not see the pedestrians due to the vehicle in front of me, so I thought the vehicle was just sitting at a green light, and that is why I honked my horn.
You weren't ticketed because you honked your horn. You were ticketed because you gave a prolonged blast on the horn. You were eastbound on 13 Mile Road. The driver in front of you was waiting for pedestrians. There is nothing stopping you from seeing pedestrians, blocking your view of pedestrians if you're in the second lane behind the car. And the fact that you didn't see why the person wasn't proceeding doesn't mean that you can just fill the air with your horn.
Yes, Your Honor.
There's a lot of tickets that could be just described as rude driving. This is one of them. I do believe you are responsible as cited, and the fine is $130. You can pay it online or by mail, or you can pay it at the courthouse counter if you prefer. Thank you. We're done.
So yeah, as I referenced in the chat, I did just look it up, and you know, I'm a big reader of Orwell. I've read much of his works, and yeah, here it is from 1984. Horn crime does not entail death. Horn crime, rather, is death. Straight from George Orwell. I'm surprised she got up with just $100 and some fine.
Ms. Brown, are you back?
Hi, yes.
Do you have the new registration with you?
I do not. I only have the registration that expired in 2026, but I do have updated tags.
Where'd you put the registration?
I thought it was in the like inside of my car, but
Yeah, that's where most people keep it, I think.
yeah, it is.
If you were to be stopped for a stop sign violation or whatever, what the officer always asks for is your driver's license, registration, and proof of insurance. So you really need to be able to show that to the officer. You're sitting in the car now and you can't find it.
Yeah, I only have the old one. I don't have the current one that came with the tags that I just got.
Yeah, you're gonna need that. Have you checked this, officer? Did you check to see that the plates are renewed?
I checked it this morning. Everything is up to date.
Okay. Is there anything you want to add to this?
I'm okay with dismissing it. She would just obviously need to get some new proof of it, but everything's up to date and clean.
Ms. Brown, the ticket is dismissed because of the officer's motion to dismiss. However, you really should find the registration, because if you should be stopped, and there's no reason to think you're going to be stopped, but if you should be, that's one of the things three things that the officer will always ask.
Okay.
So if it's lost, you can get a duplicate from the Secretary of State.
Okay. Yeah, I'll go get a duplicate.
It might be easier to look again, but give it a shot.
Okay. Thank you.
But the ticket is dismissed.
Okay.
Let's call this back. We have Mr. Ramirez.
Yes, sir. Good morning, sir.
Good morning. This is 25R01725, people of the city of Royal Oak versus Reynaldo Hernandez Ramirez.
Good morning, Your Honor. Attorney Susan Cole on behalf of Mr. Ramirez. Your Honor, we're here for the purposes of arraignment, and we do agree to this proceeding and future proceedings by Zoom. For purposes of arraignment, I do waive the formal reading of the charge, ask that a not guilty plea be entered on his behalf, and he would have me continued as appointed counsel.
Thank you.
I can also confirm for the court that the address on 13 Mile Road is accurate. And there was a phone number also included in my register of actions, which was correct too, which ends in 3058.
Plea of not guilty will enter. The next step in the process here is going to be a pretrial conference. You'll be notified of that conference date and time by mail. It'll be a Zoom hearing, but it will not use the same Zoom numbers that you're using today. Ms. Cole, is Mr. Ramirez requesting appointed counsel?
Yes, Your Honor, he is.
If he would stay on with you, and ask Devon, please.
Your Honor, he's.
I'm sorry, before I ask you, he is paid bond.
Oh, how much, Your Honor? Or what type?
It reads 7/9/26, $500, 10% bond by defendant posted at ROPD 7/8/26. Defendant released from custody. So he paid his bond. So the bond will just continue. And what I'm trying to ascertain, find out, is the name of the alleged victim is Vance Fasano. So there'd be no contact with the alleged victim Vance Cassano. Mr. Ramirez, when I say no contact, I mean nothing. Not mail,
sir.
not phone, not social media. There's no contact. If he's there, you walk the other way. Only round is bond. You may not purchase a weapon. You may not carry a weapon or possess a weapon. Firearm. You own a firearm, sir?
No, sir.
Okay, now you're going to get the pre-trial notice in the mail. It'll include the new Zoom contact information for that matter. You would be represented by Ms. Cole. You're good here today. You can go. Have a good day, sir.
Thank you, sir.
Good morning once again, everybody. Happy Wednesday to you. It is TCF Live. My name is Dan. It is good to have all of you here with me this morning. Reminder, episode 3 later today of second session, 2:30 Eastern, 11:30 a.m. Pacific time. Our brand new show, more court, but different from how you see it in the morning, so do give that a look later today. Let's go to Lake County, Ohio. Let's check in with Judge O'Donnell, see how much swearing he has to do today.
Seated. Mr. Geigerich.
Thank you, Your Honor. Before you today on State versus Ronald McCauley, file 26 CR 387. We're here today for an information. It's anticipated by the state of Ohio that the defendant will waive his right to have his case presented to the Lake County Grand Jury and to proceed by a one-count information, and furthermore to enter a plea of guilty to that one count. Other than what's been spread upon record, no threats or promises were made to this defendant to induce his plea. Thank you.
Mr. Novotny.
Your Honor, that is correct. Before coming into court today, Mr. McCauley and myself went over the waiver of indictment as well as the written plea of guilty form. He displayed an understanding about how the procedure for today will go forthwith, and ultimately would like to enter into a change of plea. Thank you.
All right. Mr. McCauley, how old are you?
76.
How far did you go through school?
Did a little bit of college at Ohio State.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
Have you ever been diagnosed
Your
with
Honor,
what?
He has.
What?
So he has taken in the last couple of days prescription medications with regard to what, your blood pressure, right?
Blood pressure, cholesterol, stomach gastritis.
Yes.
Okay.
And then 2 days ago he did have marijuana.
All right. Have you ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of the information that was filed?
Yes.
Any questions about it?
No, sir.
All right. Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Ms. Novotny some more, let me know and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the Witnesses are done testifying for the prosecutor. You have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
Do you understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes.
Theft is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, a parole authority could return you to prison for a maximum of 6 months. Do you understand that?
Yes.
Do you understand that if your violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation?
Yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I would sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer? Have you had enough time to talk with Ms. Novotny before pleading guilty today?
Yes, sir.
Has she discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice she has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
Not at this time.
Mr. Geigerich, if the case went to trial, what would the evidence show?
Thank you, Your Honor. The evidence would show that between October 6, 2025 and October 14, 2025, the defendant deposited 3 altered checks, which were from the city of Eastlake, and the loss, resulting in a loss to the city of Eastlake of $3,950. The checks were found to be counterfeit checks to where they were originally for a construction company but were changed to reflect the defendant. Thank you.
How many checks were there altogether?
3, Your Honor.
How much were they? Weren't there 2 to Willoughby Muni? Or from Willoughby Muni?
We had check number, hold on. Check number 123390 is a fraudulent copy. From the city of Eastlake.
How much?
That was the amount of $4,303.64. No, excuse me, that's incorrect. The original check was for that, and it was cashed in the amount of $975.
Well, how's that?
Because they altered the check, Your Honor.
Wait a minute. There was a check. Were these checks made out to the defendant?
They ended up being made out to the defendant, Your Honor. The original real checks were like permit refunds to Lorenzo Construction and things of that nature. The checks were then altered to reflect the defendant.
So a dummy check was made up?
Yes.
Not all,
so
that check was
that
altered.
the actual check number, there was a real check for it, but it wasn't the one that was cashed. So the second one is 123399. It was made out to the defendant, and that was in the amount of $2,975. It was originally a check that was issued to a different individual in the amount of $75, again for a permit refund.
Using that same check number?
That check, yes. So you have check number 92 and 99 of that series, Your Honor.
Okay.
So there are two different permit refunds which were altered to be the amount that caused the loss of the $39.50.
And what about the Willoughby Muni checks? The two $500 ones that I had seen made out to the defendant.
Oh, here we go. When the defendant was speaking with the cops, he talked about an individual who was texting him that led him to do this with the fraudulent checks from Eastlake. There are messages telling the defendant to move the funds into his Chime account and Zelle accounts. In addition to the City of Eastlake checks, he located a fraudulent $500 Willoughby Municipal Court check numbered 049219, and it doesn't look like he said he was going to reach out. I don't know if that ever came to anything with that. That just came up through the investigation into the original checks.
So what did he do with the money, with these checks?
He would make it available to this.
How though? Would he cash the checks? Would he deposit
Through
the checks?
he would deposit them and through his Chime account and Zelle account, make it available.
And then transfer it to somebody?
Yep.
Okay. Who's the somebody?
Aline.
Who's the real somebody?
Oh, I don't know.
Why not?
I don't know.
Okay. This is probably just a one-off thing anyway, right? Ms. Novotny, anything to add to the facts?
Nothing to add to the facts, Your Honor.
Mr. McCauley, did you hear what Mr. Geigerich said, that the facts would show if the case went to a trial?
Yes.
Are those facts true?
Yes, but somebody in the internet did this. I didn't do this intentionally.
Right. I understand exactly what happened. And And somebody out there is probably doing the same thing over and over again. It'd be nice to find out there's somebody out there,
I
but
want to catch them if I could.
what's that?
I'd like to catch them if I can.
Me too. All right, but what is your plea to that charge, theft of felony 5?
Guilty.
All right, Ms. Novotny?
Your Honor, we also have a waiver of indictment.
Oh, yeah. Do you understand that you have the right to have your case presented to the grand jury for them to decide whether to charge you? You understand that?
Yeah.
Did you discuss that right with Ms. Novotny?
Yes.
And are you going to waive that right?
Yes.
All right. Good catch, Ms. Novotny.
Absolutely, Your Honor.
You should have told me that 15 minutes ago.
I didn't want to interrupt, Your Honor.
Oh, okay. All right. It's going to be a banner day here.
Your Honor, in open court, myself and my client signed the waiver of indictment, passed the prosecutor, witness the same.
Thank you.
And then I need you to sign here and date. Today's date is 8/5/26.
Approach.
Sure.
And then your signature right there. Your Honor, myself and my client signed the written plea of guilty and passed the prosecutor, witness the same.
Thank you.
All right, I'll accept the waiver of indictment. Mr. McCauley, is this your signature on this written plea of guilty?
Yes, sir.
Did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes.
All right, I'll accept the written plea of guilty. Defendant was present with counsel, advised of all of his rights, made a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I'll accept the plea of guilty. Find him guilty of theft of felony 5. I'll refer this for a pre-sentence report. Sentencing will be September 16 at 1:30. What's the bond right now?
Bond is currently set at $3,500, cash surety 10%.
All right, let's continue.
No,
He posts.
he posted on 3/16 of
Right.
26. Your Honor.
Let's continue.
Or it was
All right.
involved. Yeah.
We're going to go over to probation.
Yep.
And between now and September 16th, knock off the marijuana, okay?
Yes, sir.
Anything else?
Nothing else, Your Honor. Thank you.
All right.
Good morning once again, everybody. It is TCF Live on a Wednesday. There's a whole bunch of you out there already. If you have not already done so, please do take a moment and say good morning to us in the chat. This is the best, friendliest, mostest, bestest chat in all of LawTube. So please do engage us. It's good to have you here with us. Barbara, earlier, $5 for a happy Wednesday. Thank you for that. And thank you also, Barbara, for peer pressuring Ashley into giving $1 into the swear jar. So appreciate that. And thank you, Ashley. Let's do this. Let's go to Otsego County, Michigan, where justice is best served in a converted pole barn. This is Judge Mertz.
Ms. Harris is present here in the courtroom today. It's the date and time set for sentencing. You have counsel put your appearances on.
Thank you, Honor. On behalf of Ms. Harris.
Thank you. Ms. Harris, have you had an adequate opportunity to go through the pre-sentence report and talk to your attorney about that?
Yes, Your Honor.
Okay. Mr. Trush, you've been able to go through that report with your client.
We also received from the prosecutor's office a victim impact statement, and we went over that as well.
For the record, I did get a support letter on behalf of Ms. Harris as well. I had a chance to review that prior to the hearing today. Mr. Trush, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor. I do just want to make sure. I think we sent 2 letters before we both of them.
I just got to one. I can't read the can't make out the signature. I was able to read the letter. The letter's legible with the signature. Oh no. Also one from Ms. Bly and Mr. Grant.
Okay.
Okay. Yep, I did get both of those.
No corrections.
Okay. Are there any challenges to the scoring?
No, Your Honor.
Mr. Ronald, do the people have any additions, deletions, or corrections?
No additions, deletions, corrections. I would advise the court that pursuant to the cases with the Crime Victims' Rights Advocate, the victim is not going to be present for purposes of sentencing, but she did want the court to take into consideration her statement as contained in the PSI. Okay.
Thank you. Anything on behalf of the people then for allocation?
No, this is a situation where 74-year-old woman was taken advantage of. That's, I guess, the only way I can really state this. It may be that Ms. Harris is good at what she does, and by that I'm not trying to be sarcastic. I mean, in regards to the services she can provide, cleaning, whatever the circumstances are. However, that does not, I believe, justify the other part of what she does, where she's trying to take advantage of persons who might not know us being taken advantage of. And I simply ask the court sense to take that into consideration. Thank you, Judge.
Thank you, Mr. Trush.
Thank you, Your Honor. I think that the PSI here does a good job of capturing what's going on here, both in terms of balancing what happened here and Ms. Harris's personal situation, her specific situation. What we have here, I think, and I certainly can understand reading the victim impact statement, how a victim can feel. Certainly there's not a right or wrong answer. Certainly I understand how she feels about being taken advantage of. But I think when we look at Ms. Harris's history here, what we have is someone who's 56 years old and really has not had any substantial interactions with the criminal justice system. I think there's a prior OWI offense a couple of years ago, but really largely has lived her life in the way that we would expect someone to do so. She's not had trouble in the past with the law. In this circumstance, as the PSI indicates, I think she's accepted and acknowledged that there was some motivation from her of desperation from personal circumstances that she was having. I think that she is thoroughly embarrassed and regretful about what happened. She's expressed that to me on numerous occasions. She's expressed it to the PSI operator, and I think she's going to express it to Your Honor as well. As we were getting ready for this hearing, I mean, I think frankly, this about sums it up as best as I can to the court. I mean, she told me basically I have to live with the guilt of what I did for the rest of my life. I think that that is indicative of someone who understands what she did was wrong, understands the impact that it had on other people. But I don't think that we should let that have us lose sight of the fact that she has generally lived a life that has complied with the law, been exactly what we would expect, and frankly has been helpful to other people. The letters here that we provide to the court show a completely different side of her than what I think the court gets. I think the recommendation here to hold jail in abeyance is entirely appropriate. The guidelines range here of 0 to 11 comes with a presumption against jailing. The restitution has been made in this. Actually, I think it's been made sort of twofold over because the bank both returned the money and I think she returned the money as well. Not that that matters, but I mean, it does go to show that she's making every effort to make right on this. And I don't think this is really reflective of who she is. So again, I think that the recommendation here is appropriate.
All right, thank you. Ms. Harris, was there anything you wanted to say today?
I just want to apologize to you, Your Honor. Apologize to Ms. Decker several times. I apologize to Mr. Rolla and Ms. Linnell. My attorney is having to take up time for something that I did. I am truly sorry. what I've done. There's no excuse. There's no good excuse for what I did. It doesn't matter. The issue is what I was dealing with. I'm very sorry.
All right, Ms. Harris, I did read through the report, so I'm familiar with the circumstances that bring you before the court today. There's also a lot of information in there about you and your circumstances personally. And I take all of that information into account along with what the lawyers have had to say and with what you've had to say. Again, I did read the letters too that were submitted on your behalf. And I think what the lawyers both had to say is pretty much on point. There's two sides to this. Clearly, you know, at your age, you're in your mid-50s. You really don't have much of a prior record. One recent charge for drinking and driving, but other than that, you know, you don't have anything. So clearly, you're not a person who's engaged in a course of conduct of victimizing people. This appears to me to be a crime of opportunity, and certainly reasonable excuse for having done this is the personal troubles you were having. It certainly doesn't make the conduct okay to take advantage of another person, to change the numbers on a check to be able to get more money. And, you know, I just don't think there's a way that this wasn't going to be found at some point or another. And so to me, that also indicates the kind of desperate circumstances that you were in to do something that ultimately you were certainly going to get caught for sooner or later. The other side of this coin is, of course, the victim in this case. When someone steals from you, that's a very unsettling and fearful experience, traumatizing experience for that person. It makes it hard for them to trust anyone else going forward. And it makes that person leery of having other people help them, and that's detrimental to that person. So there's a price to be paid for that as well. I think balancing those two things, recognizing that this is a nonviolent crime, recognizing, as Mr. Trush has indicated, that we have the statutory presumption now in cases like this against jail time unless there's some aggravating circumstance. I think the recommendation is completely appropriate. It's going to give you the opportunity to avoid having jail time and to serve a period of probation, but it's also going to allow for the court to hold some jail over your head so that if you don't comply with probation, there will be that penalty there. So the court is going to order that you serve probation for a period of 12 months. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in this report. The court is going to order that you serve 3 months in the Otsego County Jail with credit for 2 days served. The court will hold that time in advance to be served at the discretion of the court. So again, if you comply with probation and you successfully complete it, you would never have to serve that jail time. If you don't, though, the court can impose that jail time immediately without any hearings, just straight to jail. So I hope that that's a motivating factor for you in complying with your probation. The court is going to order a crime victim's assessment of $130, the court cost of $325, attorney fees of $350, the DNA testing fee of $60, $136 state cost, and a $30 per month supervision fee while you're on probation. And Mr. Rolla, just so I'm clear for the record, I don't need to order restitution.
No, Judge, restitutions were made for already prior sentence.
Okay. You do have the ability to seek an appeal of this sentence, and that's for both counts to run concurrently. Mr. Trush, have you been able to provide the appellate rights to Ms. Harris?
We went over them yesterday. I'll go over them with her again today. I would indicate to the court, she reports to me that Social Security is her only source of income, so this may be a case where waiving the court-appointed attorney fee would be appropriate.
That's something that I'd like maybe probation. That's something that we can look at as if she's unable to pay that through probation, the court may waive that later on.
Understood.
Okay. I guess you should.
Thank you, Your Honor.
All right, good luck to you going forward, Ms. Harris, and just make sure you meet with Ms. Davis before you leave.
Alrighty, friends, moving from converted pole barn justice a little bit south to high humidity swampland justice, where you can get a $50,000 bond for fishing out of season. I give you Judge Mercer.
Mr. Franklin, good morning. Mr. Franklin, your sister and the alleged victim are both in the courtroom. You're here because you've been accused of another count of battery. This is battery second or subsequent, which is a felony charge. Mr. Franklin, I have read the complaint. There is probable cause for the charge. Mr. Franklin, listen to your attorney, and we'll go from there. I know that you're already out on bond in 26-365 CF. That case has a condition of no contact with the alleged victim, and that bond happened before the most recent charge allegedly occurred. Mr. McDaniel, anything on behalf of Mr. Franklin?
Your Honor, we just asked for a reasonable bond, and I'll let his attorney know that he's over here.
Thank you. Mr. Mitchell.
Your Honor, the alleged victim has been in contact with the state regarding the 26365 CF case. She has expressed that she doesn't want to pursue charges. However, I'm sure she's been informed that it is the state's decision about whether or not to pursue charges. And I've spoken to the ASA that's over that case. They still are proceeding with the charges right now. So based on that, the state will request that his bond be revoked based on the new charge and also allegations of contact with the alleged victim.
Thank you both. So, Mr. Franklin, I'm going to set your new bond, your bond in the new case at $10,000 cash or surety with a condition of no contact with the alleged victim. Don't try to post it because I'm revoking your bond in 26365 CF, and I need the order to say both the new charge as well as having contact, which is a violation of the bond. There's certainly probable cause that he did both. So, Mr. Franklin, don't try to post a bond. You're not going anywhere. Even though you've got a bond in the new case, you don't have a bond in the case you had already pending, and you do have the condition no contact with the alleged victim if at some point you're ever on bond in the new case. Mr. Franklin, the other thing is that the jail's going to give you a notice for your court date. Your court date in the new case will be
September 1st.
September 1st at 8:30. And Mr. McDaniel, as he said, it's going to notify your attorney in the old case that you're in jail with no bond. Let me see if your sister has any questions. Ma'am, do you have any questions? Ma'am, do you have any questions? Mr. Franklin, do you have any questions?
Is there any way that I can get my bond back on this old case?
Did you post a cash bond or a surety bond?
Cash.
That'll be judged. If you went to a surety, you couldn't get it back anyway. That's the contract you had with the bondsman. You're not entitled to get it back. If you posted a cash bond, Judge Garcia would decide what to do with it. Go ahead, sir.
What I was asking was, is there any way I can get it reinstated or whatever?
Oh, absolutely not. You allegedly had contact with someone that myself or another judge ordered you to have no contact with, and allegedly committed a new crime on that person again. Well, it's allegedly, and you've got about 20 pages of criminal history, so you're not going anywhere, Mr. Franklin.
Thanks, sir.
Have a good day, sir. Ma'am. September the 1st at 8:30 will be his court date in the new charge. I don't know his court date in the old case, but he'll find that out on that day.
I think it's September 15th.
Yes, ma'am. Thank you for coming. It'll be after the.
Oh, I was just going to say the PD's office. I think he was given a September 15th.
Yeah, I can check it for you.
I think is what it was.
October the 20th, but I don't know what time.
It was October, but I looked at it this morning, sometime in October, I recall.
That's right.
Yeah, I have the date.
Marcus seen September 1st, and if not before September 1st.
Yeah, so see on September 1st, because that may change the October date. What they're probably going to do is put them both together. So you need to see what happens on September 1st. Even if I give you the time, it may change when you go to court on the 1st.
Okay, so just ask them then.
Yes, ma'am.
Okay, thank you.
Okay, thank you. All right, so Mr. McDaniel, the next case we have is Joseph Betros. Mr. Betros, good morning. You're here because you've been accused of violating the terms of your state probation. I've got a copy of a warrant in front of me. It's signed by the circuit judge. It has no bond on it. Mr. Betros, that means you're going to be held with no bond until you can get over to circuit court and try to get this case resolved. We're going to tell you when that court date is in just a minute. Before I do that, I'm going to go ahead and arraign you. What that means is I want to get you a lawyer appointed to represent you if you would like one. Would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent you. Listen to Mr. McDaniel, and I'll see if you have any questions in just a minute.
Your Honor, we're going to plead of not guilty. As set this on the September 3rd court docket, and I advise him that the attorney from the PD's office will come down and visit him prior to that hearing.
Thank you. Mr. Mitchell, anything from the state?
No, Your Honor.
Thank you. Mr. Betros, any questions?
Any questions? Nice. All right, good luck to you.
Have a good day, sir. Wayne Gates. Mr. Gates, good morning. Mr. Gates, you're here because of a warrant out of Washington County. I took a look at it this morning to see if it had a bond on it, and it does not. It's a violation of probation charge signed by a circuit judge over there, and it has no bond on it. So, Mr. Gates, what that means is you'll go to Washington County. Today's Wednesday. You probably will go this week, maybe even today, but it's not extremely unusual if it was the first of the week. Usually it's within 4 or 5 working days. So when you get to Washington County, you go to another first appearance, but the warrant has no bond. Do you have any questions, sir?
No, sir.
Hang on, the clerk has a question. Yes, sir. Yes, ma'am. No, it wasn't, but the violation of probation is not going to revoke that bond here unless it's based on something.
There's a lot of moving parts when it comes to his cases between here and Washington County, and
yeah,
I'm not up to speed on like the possibility of a global plea when it comes to both of those cases.
So, Mr. Gates, I know that you're out on bond here. I'm being told that that doesn't change anything. I do want to kind of concern about your court date here. When is your court date here, if you know?
September 15th, but I've already been accepted to go to a program in South Florida. I spoke with my public defender yesterday on that case, and said that we could do it via Zoom if I was in the program, if he could verify I was in the program. So I'm hoping to get up to Washington County as soon as possible so I can go to South Florida because I've already been accepted.
Who is your lawyer here?
Mr. Roberts.
J.Y.
Mr. John Young Roberts. Okay. Sounds good, Mr. Gates. Sounds like Mr. Roberts is aware of everything, but this doesn't affect your bond here at all because it's a VOP. Okay. Wish you the best, sir.
Thank you.
Yes, sir. We have Lorenzo Miller. Mr. Miller, good morning. Mr. Miller, you're here for first appearance accused of one count of failure to appear for arraignment in 26336 MM. Mr. Miller, I'm going to appoint you to the Public Defender's Office to represent you and ask that you listen to Mr. McDaniel, your attorney.
Okay. Your Honor, I spoke to Mr. Miller. He's going to plead of no contest to the charge listed, understanding 10 days in county jail, 1 day jail credit, $370 fine. He has signed his waiver form, waiving his right to jury trial and call witnesses. It's going to resolve this case today.
John, could you repeat that? The papers were hitting the mic while you were speaking.
10 days in jail, 1 day credit, $370 fine.
Mr. Mitchell, when I looked at the arraignment docket, there were other charges the state was going to dismiss if he entered this plea, but it didn't say what those charges were for.
They were all for trespassing at different Dollar Generals. So,
is that still the plan?
Same? Yeah, that's the same.
You want to put those case numbers on the record then?
Yes. MRB cases 2690, 26331, and 26370, all MRBs.
Same Dollar General or different?
I think it's the same Dollar General.
So, Mr. Miller, the state's dismissing those other cases as part of this plea agreement, but you need to understand that no trespassing warning, the trespassing warning you've been given still applies even when you get out. Any questions about that?
No, sir.
Is that the plea you want to enter, sir?
Yes, sir.
Mr. Miller, I'm going to accept your plea of no contest in case 26-336 MM to the charge of trespassing. It's a first-degree misdemeanor, Mr. Mitchell?
Yes.
First-degree misdemeanor. A judge who guilty of that offense sentence you to 10 days in jail, give you credit for 1 day, impose court costs and fines of $370. Mr. Miller, when you finish this jail sentence, you're through with this case. There's nothing else that I know of that's still pending, but you need to realize you've got that no trespass warning. Don't go back there, okay?
So don't go back and then also pay the $370 and I'll be good.
Yes, sir. Any questions?
All right. Oh, that's good. That's all that.
Wish you the best, sir.
Okay, yep. And what else is this?
Edmond
We have-
Williams.
I'm sorry?
Edmond Williams, is that all right?
Sure. Edmund Williams next. Mr. Williams, come on up. Mr. Williams, you have a holdout of Calhoun County. I took a look at that case. I like to look at the warrants just to make sure there's no bond, or if there is a bond. There's no bond set on that warrant. You're accused of some type of fail to register cases in Calhoun County. So what's going to happen is you're going to be held for Calhoun County. You'll get down there the next day or two, maybe even today. When you get there, you'll go to another first appearance, and that judge will address your bond and may or may not set your bond, depending on whether they think you're entitled to one. But right now, you don't have a bond. Do you have any questions?
No, sir.
Wish you the best, sir.
Paisley D.
Paisley D. Dean, good morning. You're here because you've been accused of one count of possession of controlled substance without a prescription. Miss Dean, I've read the complaint. There is probable cause for the charge, ma'am. The criminal history I've been provided says no prior criminal history. Is that accurate?
Yes, sir.
You have never been charged with a crime anywhere, correct?
No, sir.
Miss Dean, the other question I have is under employment, it says NA, not applicable, I guess is what that's supposed to mean. So Miss Dean, you're 26 years old, is that right?
Yes, sir.
You don't have a job?
No.
Are you a student?
No, sir.
How do you live? How do you provide for yourself?
My mom.
You live at home?
Yes.
So what do you do all day? A 26-year-old that don't have a job, doesn't go to school. What do you do?
I take care of my dogs. I got 6 dogs.
All right.
And I breed dogs. I don't know. I breed dogs and sell them.
Okay. Mr. McDaniel, anything else on behalf of Miss Dean?
No, Your Honor.
Mr. Mitchell?
Regardless of whatever release option she gets, we're going to ask that she be subject to random UAs.
Mr. McDaniel, you prefer a cash bond? I'm not going to give her conditional release. She's 26, doesn't have a job, doesn't go to school. Not being very productive at all. Cash bond, $250 cash bond, ma'am. Mr. Mitchell, any objection to a cash bond?
No objection.
$250 cash bond, ma'am. You have a condition of random error analysis. There's a good chance, a very good chance, Judge Garcia will drug test you, ma'am. So just be aware of that. If you fail the drug test, there's a good chance your bond will be revoked. But in the meantime, you've got a $250 cash bond. You will get to use the phone in a few minutes, ma'am, to try to post the bond. If you post the bond, you'll be released. The jail will give you a notice for your court date, which should be September 1st at 8:30. Do you have any questions, Ms. Dean?
No, sir.
Have a good day, ma'am.
Thank you.
Yes, ma'am.
Amanda Edwards, aka Amanda Castleberry.
Good
Ms. Edwards, good morning. Ms. Edwards, you're here because you've been accused of one count of aggravated assault with a firearm. Excuse me, it's not, actually the jail sheet says that, but I don't think that's what the complaint was for. Well, you know what? Just a second. Let me finish and I'll see what questions you have, okay? So the jail sheet is correct because the jail sheet tracks the complaint. The problem is the complaint is wrong because when I read this complaint, there was never a reference to a firearm at all. In fact, the allegations is it was a knife. So the body of the complaint, Mr. Mitchell says deadly weapon, which is correct. But on the front page of the complaint, the officer put firearm. So I think it's just a typographical error. I need to notify the officer, the deputy, that he needs to correct that and be aware that he's got to.
It's weird in this situation because it makes mention to a knife, but it also makes mention about how there was like 2 instances where she said she was going to shoot the alleged victim. So there's mention of a possible firearm being used, but they never say firearm, but they just mention knife.
Can I mention, he was arrested 2 months ago.
I want you to be quiet, please, until we get through with this part right here. And I'll be glad to listen to you when it's your turn. It's not your turn yet. There's never a reference to a firearm being used, period. Therefore, there's no probable cause for aggravated assault with a firearm. There is probable cause for aggravated assault with a knife. That's what I'm finding probable cause for, Mr. Mitchell. I need to notify the officer and tell him he needs to be more careful in doing his complaints. And the front sheet doesn't match the back sheet in this particular case. So there is probable cause. You've got a lengthy criminal history, but I still think you're entitled to a bond. I'm going to listen to the attorneys and I'll listen to you. Then I'll address your bond. Mr. McDaniel, anything on behalf of Ms. Edwards?
No, Your Honor.
Mr. Mitchell.
Nothing, Your Honor.
So, Ms. Edwards, I'm glad to listen to you, but ma'am, do not talk about the case itself. We are being recorded. I don't want you to say anything that is going to come back and hurt you. But if you have something that you think I need to know for bond purposes, or something that you have a question about, if you have bond purposes or a question, ma'am, stop talking, please. Let me get through talking before you start.
Okay.
If you have a question or if you have something that you think is important for bond purposes, not about the incident, about your employment, anything like that, you can't help yourself, can you? If you will let me finish this sentence, I'll be very grateful. That's the only thing I need to know. Do not talk about the incident. I'm familiar with your history. I'm familiar with some of your mental health issues in the past. But if you have something I need to know or a question, please go ahead. Mr. McDaniel.
This is the issue. The original judge from Panama City, I came from Panama City when I was living there, came to this courthouse here. The judge, the original judge started talking about sign the paperwork because he was charged with murder of the original Michael Castleberry. They are not kin to me. I do not have a criminal history whatsoever. I worked as an officer. The last job I had was over drug task force in Wong County. Where I came from Ponce de Leon, not even 6 months ago, he was removed from the property. My son was working here at the jail. I have no criminal history whatsoever. That's a lie. The other part was that the judge signed because of the murder that was on my property there by Michael Castleberry, that if they tried to rearrest me, there'd be no bond set for me again because they were lying, trying to claim I was family. The judge signed the order and said that if they'd done that again, I had to sue because they kept trying to rearrest me 7 years. For 7 years straight, trying to play that out that he was family. So the Panama City judge said that if they did it again and tried to set a bond and rearrest me for what the criminal history of them harassing me and where I had sued, not even 6 months ago, my son was working in the Phoenix Springs, brought the paperwork from there to here to get where they were moved. They were removed. I went last week up to your courthouse. And they said they would remove him. They removed him a month ago. Sent a deputy from your courthouse, had him moved with a weapon. They won't listen to me. They're doing the same thing they done while I sued. But the original order was that if they ever stated on that paperwork for a bond or try and hold me again, stating that I was anything to do with what that was, that they couldn't do it. My son provided that paperwork not even 6 months ago, showing them out.
Mr. Jailer, the criminal history I'm showing appears to be the same person. Mr. Jailer, is it the same Amanda Edwards you've had multiple times?
Yes, sir, it is.
Ma'am, your bond is $5,000 cash or surety with a condition of no contact with alleged victim. Ma'am, wish you the best. Mr. McDaniel, that's everything I had on my list this morning. Anything else from the Public Defender's Office?
No, Your Honor.
Mr. Mitchell, anything?
All right, that does it for Judge Mercer. Good morning once again, everybody. Creeping up on hour 2 now of TCF Live. Good to have you here with me. So yesterday, Michael Groff was asking me, why haven't we seen much Judge Simpson lately? Well, because I haven't shown him. But, per your request, here's a little Judge Simpson.
People, Your Honor, the people would waive any potential conflict between this honorable court and the office of defender, while the people do not believe that any such conflict exists, who makes this waiver in the avoidance of all doubt.
Mr. Buckovich.
Good morning, Your Honor. Assistant Public Defender Nicholas Buckovich. Likewise, Your Honor, this is between this honorable court and the office of the public defender. However, we do want to inform them.
The court, for its part, also does not believe there's a conflict either in Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case. Side up. People State of Michigan versus. I lied. Chastity.
That's me. That's me.
I'm going to see you.
All right. Hello, Ms. Newman. Can you state your name for the record for me?
My name's Chastity Newman.
All right. We're trying to find your attorney.
Okay.
Good morning, Your Honor. Christina Saxon for Chastity Newman.
All right. She's already identified herself. Court has before it a plea form that indicates going to be pleading guilty to the charge of retail fraud 393 offense. Upon a successful plea to that charge, count one would be dismissed. Prosecutor is recommending a fines and cost sentence, and that restitution be held open for 30 days. That's the court's full understanding of the agreement.
That's correct.
Your Honor, we are asking though for time served. Ms. Newman is in Huron Valley's prison and until May of next year. Then will be transferred to Indiana State Prison for more than a year. So given that much time, we would ask for time served with a waiver of all but the statutory fees rather than fines and costs.
So everybody's agreed to a fines and cost sentence, but now you want to change it.
Actually,
People have no objection to that, given that she's going to be serving time and leave it.
we had discussed it.
It's what I was going to do anyway. So I don't know why you, yes, I do nice things occasionally, Mrs. Sachs.
We're still learning one another, Your Honor.
What'd you say?
We're still learning one another.
Oh, no, I got you pegged.
I did too.
I don't. You might be learning me, but I got you pegged. Ms. Newman, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, state your name again for the record, please.
My name's Chastity Lynn Newman.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud third degree. That is a punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the amount taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes,
And to that charge, how do you plead?
I plead guilty.
Now you understand that by pleading guilty, you'll not have trial of any kind.
Yes, sir.
You signed or had signed on your behalf an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
You understand that you're waiving or giving up those rights, including the rights in paragraph 5, which are your trial rights.
Yes,
Do you
sir.
understand? All right.
Yes.
You understand? You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole? That'd be a no.
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead guilty?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're indeed guilty of this offense?
Yes, sir.
On the date of November 11, 2021, at the location of 5450 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, what do you do at the Sam's Club that makes you think that you're guilty?
While the store was open, I went in and I took merchandise, passed without paying, and left the store.
Okay. And you indicated the store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take this property, did you?
No, sir.
And the property that you took was offered for sale by Sam's Club?
Yes, sir.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
Yes.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Ma'am, anything you want to say before I impose sentence?
No, sir.
All right. I will sentence the defendant to the statutory minimums of $125, 93 days incarceration, credit 93 served, and restitution will remain open for 30 days. Anything further?
Nothing.
That on my own.
You're doing pretty
Oh.
well. What a good work.
Well, thank you. That's no. It's Saxon. No, I wanted to take offense. Ms. Newman, thank you.
You're welcome. You have a blessed day, sir.
You do the same.
Thank you very much.
Court calls the case. People versus Antoine Reed.
Your Honor, Raymond Cook for the people.
Good morning, Anna Christina. Mr. Approaching.
Who again? Ain't
Because I want to make your day.
doing so well. Your name, sir?
Antoine Reed, Your Honor.
Right. All right. What are we doing?
Your Honor, prosecution and I have agreed to an adjournment on this matter so that they can obtain more information.
During this matter to September 2nd, 2026, 9 a.m. If that date works for you, Miss Saxon, or are you out of town again? Really? Okay. Like traveling again, as you always are.
Life balance.
All right. Bond. Court does call the case. People versus Jason Braswell.
Your Honor, Raymond Cook.
Good morning, Your Honor. Zach Ways on behalf of Jason Braswell, who stands at the podium to my right. Please introduce yourself to the court. Jason Braswell.
I have before me a plea form that indicates that the defendant would be pleading as charged to operating while intoxicated, the 93-day offense.
That's correct.
That's the court's full understanding.
That's correct.
Yes, Your Honor.
May I have him sworn?
Right here. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
State your name, please.
Jason Braswell.
Sir, it is this court's understanding you're going to plead guilty to the charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days in jail, a $500 fine plus court costs. The court could order any rehabilitative services the court deems necessary, as well as community service. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed an advice of rights form, is that correct?
Sir.
Any question regarding any of those rights? No? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights. Part of a trial, you understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, sir.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
Yes, sir.
Has anybody promised you anything other than what's been stated here today, which is nothing, to get you to plead?
Sorry, repeat. Sorry, no, sir.
Has anybody promised you anything to get you to plead? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will? And also because you believe that you are indeed guilty of this offense?
Yes.
November 14, 2022, at the location of Ellsworth Road near Carpenter, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle? Prior to operating that motor vehicle, did you consume intoxicating liquor?
I did, yes.
What'd you have and how much?
I had beer and mixed drinks, several throughout the day.
Mixed drinks with alcohol?
Correct, yes.
Kool-Aid's a mixed drink. All right. Were you stopped by the police or was there an accident?
Stopped by the police.
Why'd they stop you?
Speeding.
Are you disputing the right of the police to stop you in this case?
No, sir.
Were you ultimately arrested?
Yes.
Were you taken to the hospital?
Yes.
And was there a blood draw? And what were the results of that blood draw?
0.18 will stipulate to.
0.18?
Yes, Your Honor.
Do you have any reason to dispute those blood test results?
No, sir.
All right. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendants referred to probation. Or I'm sorry, referred to Von Schwartz for alcohol screening and assessment. Sentencing in this matter will be September 9th, 2026, 9 a.m.
Your Honor, I have a in-person matter in Detroit.
Sorry. Okay.
Is it possible to do
Another sentencing day.
the 16th?
No, we don't do it every week. We can do August 26th.
Your Honor, at this time, I have a trial beginning August 25th. I apologize. Well, September 9th was.
No, we'll work around your schedule.
I know. I can't imagine that.
September 23rd.
September 23rd? That would be fantastic if you could. I appreciate the accommodation, Your Honor.
I didn't even do anything. I said nothing. And apparently the state we're going with. What date was that again? Yeah. September 23rd, 2026. Is that at noon or 9? 9 a.m. Thank you, Ann.
Thank you very much to you and your staff. I appreciate it.
Bond with its conditions will continue. Thank you.
TCF Live, hour number 2 now. Good to have you all here with me this morning. Thanks for joining us. Let's go to Jefferson County, Texas. Judge Stevens.
Where's it? That you?
Yes, sir. Good morning.
Okay. The defendant is present with Mr. Lane and the state. It's an announcement. What are we doing today?
Your Honor, we're just waiting on videos. If I can have 30 more days for an announcement.
I was indicted last year.
Judge, I'd like to point out, I made a offer in writing to Mr. Lane back on June 23rd of this year. The videos, of course, have been available at least since that period of time.
Why hadn't you got to it?
I've requested it and I asked if they were available yesterday and they said they're not done yet.
Judge, I'll point out
that no one has
here.
Exactly. I'll point out that no one has made me aware of the fact that he's not been given up or provided.
Who did you talk to?
I think I'm talking Renee. Renee. As the prosecutor in the case, I'm always happy to help facilitate those kind of issues if they just let me know, Judge. I'm not blaming the state, Your Honor.
I've got 2 weeks, okay?
Thank you, Judge.
Thanks. Okay.
Days that are here. What? I have 6 with you guys.
Hey, Reagan.
Yes, sir.
On Antakur Raman Khan, is that right?
Jimmy and I are still working through some things on this, and I need to.
Where is that person?
No, I can help you.
Yeah, there's right now, Jimmy's written down no offer on it because there's some other stuff he's looking at. So just looking.
Okay, today, then what are you asking to do? You got it. You stepping. Caleb Ledger or Legion. Whatever the case may be, it looks like 2 cases. 2 cases, right?
Yes.
Ledger. Aggravated assault, that's the same day.
Yes, Judge.
2 people?
Yes, Judge.
Right.
Where does that know? So. And they're doing that. Then they're doing that on both sides. And what? What are excited about? Because I have those. I'm wondering. Yeah, because it's a solid relationship with her. I'll take about that. So you're gonna have a solid relationship. Well, if you're trying to feed us the detail, those species, that's true. But you can't have a good relationship. Okay. I'm just trying to think. I'll give it one. Just file your motion and do that. Once you get into that shape, then there's other authority go and take over. Somebody else is the chair. Make t-shirts, fire away from the thing. Yeah. They'll pump people stuff, making memorize a few things. This is the court, this is the judge, this is what the lawyer does. If I go back to the different topic. Yes, the comment. Can you repeat your incidents with me? You're going. We have him send you back before he changes his life. Sad but true. It is sad. That's the sad. You're young. Should see the payments.
We're getting on a year of this, the anniversary of this incident. So what is today is announcement?
He wants to finish his song top.
Yes, this, there is no deal on this one.
Yes, sir. I understand. I'm familiar with the underlying facts. I understand perfectly.
Let me know if anybody's trying to get in contact with the victims. I'd like to know that
Yes,
so
sir.
that the court can administer some.
Reagan went ahead and had that.
Understood. Thank you, Judge.
I needed the file. I just wanted you to.
Okay. We're going to trial. And there are no deals on this. We're going to let a jury decide what this conduct is. And I've read it. And it's a most disturbing probable cause affidavit. Get a resetting. Put this to trial as soon as possible.
Yeah.
Thank you. Next is. And note on that, there is no deal,
Yes,
so
sir.
I don't forget. Joseph Williams. Joe. Is that?
Just one case, yes, Judge.
What else is over expected?
Okay, short for a minute.
Joseph Williams. I shouldn't be like a parent here. Would you wear that to church?
Yes.
You would wear that to church? You don't have any other clothing?
Oh, dirty. Oh, dirty.
What, have you heard of washing clothes?
I couldn't.
That's a regular.
Sir.
Why couldn't you?
Because I had a time to and the washer is messed up in my house.
Okay. All right. Well, so you wait until all your clothes are dirty until you go and wash them?
No,
I mean, you don't have any backup plans?
No, sir.
Because that's not appropriate. Look, just look over. Look, just look over. Look over. No, look over there. All the men are with ties. You notice? But it's something, and the ladies are all dressed up nicely. It's because this is an honorable place. This is what the Constitution, this is what the flag stands for. What goes on in this room, it's the Constitution. Respect, it's respect. And the way you're dressing, it shows little or no respect. Look, I grew up too on the planet, and I was single. I had to take care of my clothes, and I never ran out of all my clothes before I decided to wash them all again. I mean, that's being prepared. don't dress like that again in here, okay? Just show respect for all of this. And you're charged with a second degree felony of burglary of a habitation, which carries with it up to 20 years in prison. 20 years in prison. I would find that disturbingly sober and serious if it were me charged with this. All right, but you gotta act like it's important to you. All right, Ms. Minaldi is here, and it's an announcement. What are we doing? Trial?
No,
on this
if I
one?
could have 4 weeks, I just received the offer from Jimmy from Jimmy's file from Mike this morning. I
And
need,
it's 8 months old. No,
this is,
I know it was handed up on January 21st. It's getting for 8 months. I mean, the decision has to be made.
Where-
You have 2 weeks. I give you 2 weeks.
okay, Judge.
Thank you. Kimberly Free. So that's Mr. Carr, is that you? George McMotion.
What, Judge?
Hey. Hey, did I miss Daryl Lewis?
I just gave some time out. I forgot to write in.
Yesterday. Because I couldn't find that on the docket. Okay, Kimberly Free. And this one, we were charged with a second degree felony, assault, looks like on a peace officer. Now this carries with it up to 20 years in prison. Of course, it's a serious thing, and this is an announcement. What are we doing today?
Judge, I'm working through the discovery on Mrs. Free's case, so if we can get one more resetting so I can work through that. I think there may be some legal issues with this as well.
You got 3 weeks, okay? But you say there are some legal issues?
Yes, sir.
There's legal issues in every case.
I'm not trying to.
That's why we went to law school, because we don't do medicine here. It's all legal.
I don't know. Sometimes they have there some strange things that people say.
What would get my attention if you said, no, I'm doing an appendectomy today and I don't have time to give you this trial. That would get my attention.
I'll toss a tonsillectomy later, but
Hey, I had one of those.
I stayed as a holiday in select last night, so.
But you know how to do it.
I know.
You're ready.
You're welcome.
George Moten.
You're interested, or you're Mr. I'll be here all day.
Well, you heard the crowd response.
I know. I'm a lawyer, George, not a comedian.
You're telling us? Back to what's at hand here.
Mr. Moten.
Yeah.
There's some medical records that I think the defense has that wants to talk to Kenesha about that they haven't been able to. And she's at that seminar this week, so.
This was an announcement.
Yes, sir.
Again, that, let's see that. It's like one indictment was handed up in February and the other was in March. Injury to a child, which is a state jail felony. And then the continuous violence against family. That one's a new one. I don't think I've seen this one.
It's pretty new
lately.
Type of offense, too.
And this is a 3rd degree felony. So between a state jail felony and 3rd degree felony, you're looking up to 12 years in confinement, serious. And they're both felony offenses. You need how much time?
Just a normal reset, Judge, in 4 weeks.
No, there isn't anything. I'm going to give you 4.
That's fine.
Okay. Justin Patterson.
I sound like a broken record, Judge, when I'm working through the videos on this one. This is where he's indicted for threatening to assault and murder a police officer. I've yet to find the part of the video where it says murder. I'm trying to work through the videos. There's quite a few on his case, so I think we can get another reset so I can continue to work with the videos on his case.
Okay, you or Justin Patterson?
Yes, sir.
Okay, you're charged with this 3rd degree felony of obstruction or retaliation, but that's not the end of it. You've got 2 prior felony convictions, assault on a peace officer, which I can't imagine that that's going to play out well in a trial with that. If that comes out during a trial, and then evading detention all in 21. So if you're convicted of this third degree felony, and if these prior convictions were proven true, you're dealing with a second degree felony, up to 20 years in prison, and you're not eligible for probation in front of that. So there's a lot of things to think about. Well, how much time for a decision? 4 weeks?
Yes, sir.
Okay. Should be set. Okay. And Jean-Claude Butler?
Okay. I think it's. Let's make it away from pain. Good. Thank you.
You know, with these, look, on these things that are motions for examination on insanity, yeah, I'd like those. Yeah.
Judge, this is, we're trying to renew the plea. This is one that, from Monday that the family's wanting to go through with this plea agreement on both sides.
If the court recalls, you indicated Monday we set a hearing for today. I presume with regard to the introduction of evidence to support an insanity defense.
I don't, well, I can't remember since we disposed of 3,000 cases last year. This is a typical day. We're set for trial. So
No, sir,
there's a motion for examination regarding insanity. What do we do about that motion?
They were willing to waive that and plead
Is that what they're doing?
probation on Monday. I don't know if they're still willing to do that or not. I thought that's what the plan was today.
I mean, it really depends on the court. And
What does it depend on the court on?
well, Judge, we were in the process of entering the plea on Monday when the court shut it down and said that the court was going to put it back on the trial docket. So if we're going to do that, then we need to pursue that motion rather than waive it.
Well, obviously, what had been presented before me, what information I had, obviously caused me some concern to stop and back up and be deliberate on
Yes,
this.
sir. But speaking, this is something that the family was wanting you to follow, both sides, to make sure he gets some help. And I think this is the best plan to do that in the interest of justice for all involved.
So what would the plan be?
Be deferred and place him on the mental health caseload to make sure that he's taking his medications and doing what he's supposed to do for a couple of years.
Are the families here?
They're not here, Judge. They're watching on YouTube, but they've been calling. I mean, they've been calling your clerk also. So
how are they, are the families related?
Yes.
Okay, this is an intra-family situation between complainant and victims.
Yes. They're all part of one big family.
All right.
So the paperwork, we still got the paperwork from Monday. I think we can still use it.
That's what y'all want to do. Let's
Yes, sir.
forward.
Okay.
Is it on the, still on the pad?
Yes, sir. It should be from Monday.
Yeah.
Who it is? I think I logged it to the wrong one. You want me to switch them? I logged in the wrong way. That has been attached, that's ours.
This is working.
Okay, but I don't have it to use, so that's okay. I don't need one, it's fine.
Well, hey, this thing is really hot.
Yeah, they're warm.
Do they?
It's fine.
Someone for this one. Okay, we call then 25 CR 34, the state of Texas versus Jean-Claude Butler. That's you? You have to speak out, so this lady. Thank you. And you hear Mr. Wilkerson is your attorney and the state's prosecutors here. You understand you're charged with a third-degree felony of injury to an elderly persons, right?
Correct, Judge.
Okay. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment in late states that on or about November 2nd of 2024 in Jefferson County, Texas, you committed the third-degree felony intentionally and knowingly causing bodily injury to Sowillo Richard Petrie, an individual 65 years of age or older, by striking that victim in the face with your hand. Do you understand what you were charged with, sir?
Yes, sir.
This is a third-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000.
Yes, sir.
An agreement has been reached where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length. If you do well, I can shorten it to 1/3, which is 3 1/3 years. Yeah, I see there's a non-binding recommendation, but the court's inclination is to place you on 10 years deferred or unadjudicated probation, shorten it to 3 1/3 if you do well, which would be sooner than 5 years.
Yes.
Is this your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Let me ask you there was one other thing y'all had mentioned. Y'all had, I thought the parties had some agreed terms of medical or mental or.
We want to place him on the mental health caseload.
Right, everybody?
Yeah, sure.
The defendant would be placed on the mental health caseload, which means that the probation office would help you on issues that you need to address, maybe for anger management or something like that, that will help your decision making so that you don't violate your probation.
Yes, sir.
That's what we want. This court has 93% success on probation, which is 75% is the national average. We're real proud of our probationers. They do well. 13 out of 14 are successful. Is that going to be you?
Be successful, Judge.
Good. And if I follow this agreement, you have no right of appeal. Do you understand, sir?
Yes.
How do you plead to this third-degree felony? Guilty or not guilty?
Guilt.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney. Are the contents all true and correct? State's Exhibit 1 is tendered into evidence.
Without objection.
Without objection, it's admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this, it states, is true, so help you God.
Yes,
correct? States Exhibit 1. Part of the record for all purposes. Pre-sentence reports waived here.
Yes, Your Honor.
I'm going to follow this agreement and find you are pleading guilty voluntarily, knowingly, intelligently, and based upon discussions with your attorney. There's sufficient evidence supporting your guilty plea here from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. The court, though, is going to defer any finding of guilt so long as you follow the terms and conditions of probation that the probation officer will go over with you. And I am signing now. Now, there are 30 some odd terms and conditions of probation, but the overwhelming majority of these are the terms and requirements all of us have to follow. Commit no offense. Okay. Avoid bad habits. Don't associate with disreputable people. I can go on and on. See, these are like the blueprints for a good life. All of us should follow. Don't possess any illegal drugs. Dress appropriately, things like that. Most of these are just requirements for a proper, decent life. So it shouldn't be hard for you to follow. You will, included in this, you will complete anger management program, and you will be placed on a mental health caseload, which the probation office has great success with in handling these the folks. Very, very seldom do we have any problems, and the folks on the mental health caseload, many of them clear themselves of mental health problems. So it's a great program, but it's like everything else. We can put this all together, but it's what you make of it, what you do. You got to put in the heavy lifting. Are you able to do it? It's good for you. We're talking about family here, right?
Yes,
This is a family. Who chose your family? Our Creator did.
Yes.
Don't foul them. You don't want to go get crosswise with the Creator. He's got a master plan. I believe it, and I know most people believe that. But family, you didn't get to choose them. I mean, you got the same DNA as many of them. You know, it's similar DNA in your family. They're special. You got to treat them special as well. Don't treat them like an enemy. And there's nothing more wondrous than a family that stays together and is happy together. Be part of that. This you're an outsider now here. Fix this. They want you back. Get in there and do the heavy lifting and be a part of your family moving forward happily together as a family. See the probation office.
Alrighty, friends, about halfway through our Courtlandia journey here on a Wednesday. TCF Live, good to have you here. Action in the Courtroom Files store this morning. Our new friend, Magical Warrior, picked up a couple of stickers. Thank you for that. Appreciate it. And Ashley stocked up on the new Courtlandia line, got herself a sweatshirt and a notebook and a tee. So thank you, Ashley. I appreciate you as well very much. Okie dokie, looks like he's gonna go into trial mode. So let's go back to Judge O'Donnell, new contestant in Ohio.
This is 25-101, Devon Jackson, violation of community control. First violation, failed to report your contact with Westlake Police on May 8th. You understand that charge?
Yes, sir.
Second, failed to report is scheduled May 15th and May 22 of 25. You understand that charge?
Yes, sir.
Tested positive for cocaine and fentanyl at St. John Medical Center, May 8th of 25. You understand that charge?
Yes, sir.
Was in possession of 18.22 grams of fluorofentanyl, fentanyl, cocaine, and xylazine, May 8th of 25. You understand that charge?
Yes, sir.
Ms. Tomaszek?
Yes, thank you, Your Honor. I spoke with Mr. Jackson. He indicated today he would like to waive his hearing, plead guilty to the violations, and we're prepared to proceed to sentencing. Thank you.
Is that what you want to do?
Yes, Mr. O'Donnell.
What is your plea to those allegations?
Yes, Judge.
Guilty?
Guilty.
All right, I'll accept your guilty plea and find you guilty. Ms. Tomaszek?
Thank you, Your Honor. We would like to ask the court today to consider running Mr. Jackson's potential prison term concurrent. Your Honor, he is currently was just sentenced to a term back in June through Cuyahoga County of 5 to 7.5 years. So he already is serving a substantial prison time. So we would just like to ask the court to run his sentence today concurrent. Your Honor, a lot of the time on probation, he was in the Cuyahoga County Jail. He also indicated he has no support system, so he's trying to get back on his feet. He does plan on taking courses while in the prison, keeping himself productive. One of his goals is to get his CDL while he is in prison. Thank you.
All right, Mr. Jackson, what do you want to tell me before I sentence you?
I put forth my best efforts, Mr. O'Donnell. I had fell off the wagon, and it just was a downslide from there. I went homeless. My mom had kicked me out because I had stole something from her dude, and it's just been like, it's been a hassle from there. And I did want to go to prison, but you know, when you're doing things that you don't supposed to be doing according to the law, you got to suffer the consequences. And here I am now. I'm serving 5 to 7.5, and I'm back in front of you, Judge O'Donnell. And I ask that you be lenient on me.
Well, as I understand it, you reported to Ms. Crook on May 8th, and then you went out and committed whatever you committed on later that day, right?
Yes, I was having a good day, and then I was hanging around the wrong crowd, got high. He gave me some things. He gave me some party drugs to take with me before I left. I did so, and we got pulled over. And here I am now. I'm taking accountability for my actions. No excuse.
All right. Anything else?
However, I'm just ready. I'm ready to get into some programs and better myself while I'm there, so I can transition back into society in the right way, in the right manner.
All right. I considered the record statements of Mr. Jackson, Ms. Tomaszek. I've considered all the provisions on 29, 29, 11, 12, and 13, and 29, 29, 14. I'm going to sentence you to terminate your community control. Sentence you to 6 months in prison. That will be consecutive to your Cuyahoga County sentence, and the costs are assessed. Anything else, Ms. Tomaszek?
No, Your Honor. Thank you.
All right.
And the action in the store continues this morning. Austin places an order, gets himself some Courtlandia stickers, a t-shirt, and the Courtlandia tour map poster, which will go up on his wall. Appreciate that, Austin. Thank you very much. Let's go back to Michigan. Judge Wiggins. Let's check in with him.
Mr. Bosher, you can go to the table there. This is case number 263038 SD. Appearances, counsel.
Attorney Lawrence on behalf of people.
Attorney Connor Shantz on behalf of Mr. Bosher. Sued, am I right? All right, and you're Jacob Bosher, correct?
Yes.
All right, counsel, we are here for a pre-trial. A couple issues. Looks like we have a resolution, but Mr. Bosher also needs to be arraigned on an amended complaint. Looks like there was an added count 2. Mr. Shantz, were you aware of that?
Yes, Your Honor.
All right. Mr. Bosher, I have an amended complaint that alleges that on or about July 15th, 2026 in Cedar Creek Township of Wexford County, Michigan, it's alleged in count number 1 that you committed the offense of operating while intoxicated. That's what you were originally charged with. That is a 93-day misdemeanor and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle mobilization mandatory the prior, and reimbursements for the cost of prosecution and governmental expenses. In count number 2, it's alleged that you committed the offense of alcohol open container in a vehicle. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100 and community service and substance abuse screening. Do you understand those amended charges and the potential penalties?
Yes.
All right. The court will continue the not guilty plea, and we will continue the appointment, and that gets us to the resolution. Looks like it's visibly impaired. Am I correct on that?
Yes, Your Honor.
That's correct, Your Honor.
All right, Mr. Bosher, have you heard what the attorneys have said the resolution in this case is? That you'll be pleading to operating while visibly impaired, and the other 2 charges will be dismissed.
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may put your hand down. Have you had adequate opportunity to discuss this plea and your case with Mr. Shantz and feel comfortable in entering a guilty plea today?
Yes.
It's my understanding that you'll be pleading guilty to what is essentially an added count 3 of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $300. In exchange for that plea, the people will dismiss the operating while intoxicated, which is also a 93-day misdemeanor, but comes with different sanctions and penalties, along with the open intox in a vehicle. Is that your understanding of the full plea agreement?
Yes.
Back on July 15th of this year, were you on probation or parole?
No,
Were you on bond in any other file?
no,
Excuse me. Do you remember reading and signing your advice of rights form in this case where it talked about your rights to an attorney and your rights to a trial?
yes,
Did you understand those rights?
yes,
Most importantly, do you understand that you have a right to a trial, either by judge or jury, and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
yes,
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
no,
Has anybody threatened you in any way?
no,
And is it your own free choice to plead today?
yes,
And are you pleading guilty because you are in fact guilty?
yes,
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor.
No, Your Honor. Then Mr. Bosher, to the allegation that on or about July 15th, 2026 in Cedar Creek Township of Wexford County, Michigan, how do you plead to added count 3 of operating while visibly impaired?
guilty,
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on July 15th, were you operating a motor vehicle on, looks like North 45 Road in Cedar Creek Township?
yes,
And you would agree with me that that's in Wexford County, Michigan?
yes,
Prior to operating that vehicle, had you consumed some alcohol?
yes,
What had you drank?
gin and tonic and a beer.
All right, just one of each?
2 gin and tonics, I believe 1 beer.
All right. And when in time to driving had you consumed those drinks?
I believe it began like 3 to 4 hours before being pulled over.
All right. And do you believe that the consumption of those alcoholic drinks would have impaired your ability to operate a motor vehicle?
Yes,
Do counsel believe the defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes.
The court agrees. I find the plea is knowing, voluntary, and accurate. I do find Mr. Bosher guilty of operating while visibly impaired. Based on his testimony, I find that he consumed alcohol on July 15th. He was operating a motor vehicle on North 45 Road, which is a public highway open to the public, obviously, and it occurred in Cedar Creek Township. Based on his testimony, he does believe that it would have impaired his ability to operate a motor vehicle. Ms. Lawrence, just so I have them for sentencing purposes, were there chemical tests?
There was a blood draw done. You do not have the results of that back yet, but there was a PDT and that came back at 0.093.
0.93. Mr. Shantz, I realize we don't need that for plea, but do you take any exception to court having that for sentencing purposes?
There you are.
All right, we will set the matter then for sentencing because the defendant will have to obtain a substance use assessment. That's required anytime there's a drunk driving conviction in the district court. So we'll be back here in a couple of weeks. You can go out to the front window where you checked in. You'll get your next court date. Just a reminder that any bond conditions you have will continue. And make sure you stay in contact with Mr. Shantz. Do you have any questions for me at all?
no.
All right.
Just so you're aware, Your Honor, you completed the SUA yesterday. We just haven't received copies of it yet.
Okay. All right, then we'll see everybody back here if he did it. Well, probably still 2 weeks yet. All right, you can go to the front window where you checked in. Thank you.
Well, he's between contestants. Tim gifting 5 memberships. Thank you so much. I very much appreciate that.
All right, Mr. Ricker, are you still able to see and hear me?
I can, sir.
All right. So we've run your information through Lean, and it's not showing that you've been fingerprinted yet. I know you've got the card there. When did you say you were printed?
I did it yesterday.
All right.
I am able, if you guys want to, at my company here, I can scan it over if you guys need, or email it if that helps. Or if I need to go redo it, I can.
That's not going to really do me any good.
Okay.
I will go ahead based on what you've shown me and what you're saying. We'll go ahead and we'll follow through with things today. You said that was in Kent County?
Kent County Sheriff Department. Yep.
All right. This is case number 255151 ST, the people of the state of Michigan versus Brennan Keaton Ricker. Ms. Dahl, you appear on behalf of the people?
I do, Your Honor.
All right, so I know we were here back on the 22nd. We had adjourned to the defendant to get fingerprinted. He says he was fingerprinted yesterday in Kent County, although that hasn't hit lien yet. Do we have a resolution to this matter?
Yes, Your Honor, the people have offered if you were to plead to and allow, we would dismiss the driving while license suspended.
All right, Mr. Ricker, is that your understanding as to what your plea agreement is?
Yes, we talked about that last time, and we both have agreed on that, as long as it's okay with you.
All right, so it's my understanding you'll be pleading guilty to an amended complaint, so an added count 2 of allow another to operate in violation of the motor vehicle code. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100. In exchange for that plea, the people will dismiss the charged offense of operating while your license was suspended, denied, or revoked, which is a 93-day misdemeanor and or a fine of up to $500 and possible vehicle immobilization. Is that your understanding of the plea agreement?
I understand that.
Kind of a pink sheet. Sir, back on December 21st of last year, were you on probation or parole?
No.
Were you on bond in any other file?
No, sir.
And I should have asked you and I forgot, you do understand that you have the right to be represented by an attorney, and if you could not afford one would be appointed to represent you. You do understand that?
Yes, sir.
And you wish to continue to represent yourself?
Yes, sir.
Do you remember going through your rights in this case? I don't see an advice of rights form in the file, so I'm going to run through them with you just to be safe. But you do have the right to a trial either by judge or jury, the right to call witnesses for your defense at trial, the right to cross-examine all witnesses called against you, the right to testify or to be silent and not have that silence used against you, and the right to be presumed innocent with the right to be proven guilty beyond a reasonable doubt. Do you understand all those rights?
Yes, sir.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up those rights and you won't have a trial of any kind?
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead today?
It is my own free choice. Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Ms. Dahl, are you aware of any promises, threats, or inducements not made part of the record?
I am not.
Then, Mr. Ricker, to the allegation that on or about December 21st, 2025 in Boone Township of Wexford County, Michigan, how do you plead to an added count 2 of allowing another to operate in violation of the motor vehicle code? Guilty or not guilty?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. And I understand it was you operating the vehicle. So were you driving on M115 back on December 21st?
Yes, sir.
And would you agree with me, or would you have any reason to dispute that that was in Boone Township of Wexford County, Michigan?
That was in Boone Township, Wexford County, Michigan. Yes, yes, sir.
All right. And while operating that vehicle, had your license been suspended, denied, or revoked?
Yes, sir.
All right. Ms. Dahl, do you believe that well, I guess I should ask, were you aware of that? That your license had been suspended?
Yes, sir.
All right, Ms. Dahl, do you believe the defendant's given a factual basis to the higher offense of driving while license suspended and allow to accept a plea to the lesser offense of allowing another to operate in violation of the motor vehicle code?
Yes, Your Honor.
Do you also believe the court rules have been complied with?
Yes, Your Honor.
The court agrees. I find the plea is knowing, voluntary, and accurate. I do find the defendant guilty of allowing another to operate in violation of the motor vehicle code. In particular, I find back on December 21st, he was operating a motor vehicle on 115 in Boone Township of Wexford County. That's located in the state of Michigan. M115 is a public highway. And while operating that vehicle, he did not have a license. So I do find there's sufficient evidence to find him guilty of allowing another to operate in violation of the motor vehicle code. Ms. Dola, any allocutions? Mr. Ricker, you have the right to address the court prior to sentencing. Is there anything you'd like me to know or consider?
I do want to say, obviously there's no excuse for anything. I was a new dad and we just had our first daughter maybe 3 months prior. And I made a decision as a dad to do what I had to do in a certain situation. Obviously sometimes you have to make those type of decisions. And in that decision making process, we've ran into this situation. You know, I'm not proud of it, and I have been currently working on my license. I did like a packet with the Michigan Secretary of State. You know, I did an evaluation, drug testing. The only thing is now that I have to wait until February to apply. So I do apologize for, you know, making a conflicting choice and driving while I wasn't supposed to.
So you made reference a couple times that you did what you had to do. Was there some sort of emergency going on, or?
Just new parents and baby crying, and there's like I don't know if you call it like a sickness or something, but the baby was sick, I guess you would say. You know, and we just wanted to help the baby, and we were in the car for a little bit, and was just, you know, being a new parent is very tough, and you know, obviously going through this situation, you know, I've learned a little bit more about being a dad, and to, you know, that the baby will be fine. You know, I think in that moment we were just very shook up a little bit, and you know, like I said, there's no excuse for doing wrong, right? I just in the moment thought I had to do what I had to do for my daughter, you know. So
did you drive from Caledonia?
No. We went up to Great Wolf Lodge for Christmas to meet family over there, and we were driving back. So
okay, all right. Ms. Dole, why was he stopped?
Speeding 77 and a 55 zone.
All right.
And illegal window tint.
Okay. Mr. Ricker, you are employed, correct?
I own a pallet manufacturing company, yes.
All right. Well, I don't see this type of behavior in your past. I do see why your license would have been suspended, but it's also been a while since you've had any conviction. So I will keep this to a fines and costs situation. There is a $75 crime victims' rights fee, $50 state minimum, $100 fine. I find that those costs are appropriate.
Yes, sir.
I will also order the $150 court fee.
Do you mind if I say one more thing, sir?
Sure.
I just want to say I appreciate the leniency going through this court situation. Obviously, we had the address issue in the beginning, and then with me driving up there, and you know, running a business is not easy, and having a daughter has not been easy. It's been a tough year of my life, and you know, everything's kind of going into place. So I just want to say I appreciate the leniency that you have given me through the court system.
All right, thank you.
Yes, sir.
0 days jail with 0 days credit. Mr. Ricker, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that, just so you're aware.
Mm-hmm.
When we get done here, you're going to need to call the court and either make a payment or get set up on a payment plan.
Okay. Do you guys, can I take pay it full and card today, like by card or the phone?
We do take card. There is I shouldn't say obviously, but there is a service fee that goes along with that.
Yes, sir.
They'll be able to tell you what that service fee is once you call in.
Okay. Thank you so much.
Do you have any questions for me about your sentence today?
No. I just want to say thank you again. Seriously.
All right. Thank you. You're free to go.
Yeah, bye.
You as well.
Alrighty, friends, about to enter hour number 3 of TCF Live on this glorious Wednesday. Thank you all so much for being with me today. It's been fun so far. I hope you're enjoying it. Let's go to Louisiana. We'll check in with the board.
For parole is called to order. Today's date is August 5th, 2026. The time is 8:39 a.m. My name is Chuck Tillis, and I will be serving as chair today. My colleagues are on Zoom, Ms. Jerry Ledoux and Mr. Steve Prater. We're at the DLC office here in Baton Rouge, Louisiana. Staff, would you say your name for the record, please?
Jason Thompson. Sherelle Lee Bryant.
Thank you. Could I get your name and DLC number, please? Are you on mute?
Yes, sir. Caleb Givens, 742-649.
Okay, is there any staff in there with you?
Yes, sir. My name is Corporal Piggott, Piggott.
Thank you so much. Whose case is this? Prater. Mr. Prater is going to be asking you some questions today. He's handling your case. And I'm going to ask Mr. Prater to go ahead and take over.
Yes, sir. Let me get my paperwork straight here. All right, for Caleb Giddens, you're charged with battery of a dating partner. You pled guilty to disturbing the peace by fighting, and that's supposedly a violation of condition 4. Could you tell me about that a little bit?
Yes, sir. First, like I said, good morning. How you doing? I ain't plead guilty. I pleaded no contest.
Okay.
I pleaded no contest to disturbing the peace by fighting, and they gave me credit for time served, 101 days. A little bit about that. It really wasn't no situation. It was just I asked for a plea offer that would not violate my parole, and that's the charge they gave to me. If I would have stood going to court, I would have had to be coming back in front of y'all with an open charge. So I just got out of the court system late. I've been through it multiple times. But I can say that I'm blessed. I'm blessed that I was able to get that charge down off of me.
Yes, sir. Yes, sir. I agree with that. That's a serious thing, even though you pled no contest, you're saying, but you had to serve 101 days, plus you have a protective order in place. Is that correct?
Yeah, additional protective order on the victim was in place and for the court system. You feel me? Throughout the whole case, the victim never came to court. But yeah, I guess it's protocol, sir. It's out my reach, it's out my range. And me answering this question right now, it's really like me lying to you. But all I can say is really protocol.
Okay, well, you got to convince me somehow that it didn't occur, because we had an anonymous call that said that 2 people walking down the street and one was hitting the other one.
Right.
And did I say something wrong?
No, sir. I'm just listening. Still waking up.
Okay. And let's see. She said, and then the victim said you hit her with something in your hand, and then something was wrapped in a white rag, and you threatened to kill her kids and her.
Right.
And on May the 28th of 2026, at the preliminary hearing, you admitted to doing this.
Sir, May 28th at the preliminary hearing that occurred right here in the same exact office, I pleaded no contest to all that. Matter of fact, I asked Mr. Jason Thornton, my parole officer, and I think her name is Maggie. It started with an M, but I asked them, what's the meaning of no contest? They both told me, meaning that you're not saying you're involved in it and you're not saying you're guilty. I pleaded no contest. And my original words to them was, my parole officer already told me that I still have to come in front of y'all because even though I played it out to no contest on disturbing the peace by fighting, it's still saying I was involved in criminal activity regardless if the charge would have got thrown out or not. So either way the cut go, it's like, I don't know, it was like a lose-lose situation for me. You feel me? But I play no contest on both. I love my kids to death. You feel me? I love them to death. And I can't wait to get back to them and hold them again. You know, I'm not gonna lie. Like, I'm gonna tell you, sir, I'm blessed for this sit down. These 180 days that I've been in jail, I'm blessed. The reason why I'm telling you I'm blessed, because my peace rage is way more better. I'm more humble. I'm way more focused on making my life better, not just for myself anymore, but the person that I'm in love with, my kids, so they don't have to go through none of these steps that I went through. I've been doing this as a juvenile. I'm blessed because I wake up every day with a purpose and a meaning now. At first, it was never none of that. I never had a meaning. I never had a purpose what life was. I took it as a joke. But right now, I can tell you, sir, honestly, I'm blessed because I had this chance to come sit down and get my head together. I'm ready to get back to my churn. I'm ready to watch them walk across the stage in schools and stuff like that. I'm
Okay,
blessed.
where were you working when you were out of jail?
I was working at PMI for about like a month, and I got a lawsuit on PMI right now because PMI tried to force me into see what the kind of work we was doing was cleaning tanks. PMI tried to force me into a tank while my asthma was acting up, and they had no medical staff on the job site. So right now, my papa is handling that lawsuit for me right now, and they just waiting for me to come back home right now. The lawyer and my papa for the settlement.
So where are you going to go to work when you get out?
My brother got all right. It's two places I could go to work at right now. My brother got a job for me. He owned two. Well, he don't own, but he rented two wing stops. One in Cancun, one in Thibodaux, Louisiana. Both of them in Louisiana. Then I got my oldest brother. He worked for G&J, and he said he could get me on working over there as soon as I come home. Long as I could pass a drug screen, they both could get me on.
What would you be doing over there?
J is he in the freezer. I ain't asked too much. Yeah, I didn't never ask him too much about it, but he do the shipping and stuff in the freezer, like packaging and stuff like that. I guess Wingstop, fry station, something like that. Anything will work though. Anything will work. To see where I come from.
Does your asthma keep you from working?
No, sir. It's just like at PMI, you deal with a lot of chemicals. So I guess the chemicals must have flared up my asthma again. My asthma only act up once a year, like around the month of December. And I gotta go get a steroid shot. And I told my boss that when I was working for PMI, and he took 40 hours away from me. Took 40 hours that I worked for hard from me. So like I guess I went with the lawsuit mode. That's the only way I could settle that.
Okay. Well, I don't, so we need to hear from Miss Gant. Miss Gant, would you introduce yourself? And
Mr. Prater,
yes.
let me correct a few things I made. I need to get a questionnaire. Do you have a questionnaire in front of you, Mr. Caleb?
A questionnaire? What's that?
We're gonna put it up. Did you sign that?
Yeah, hold on. I don't think I have that sheet though.
Okay. Yeah, it's a copy of your signature. And also, we're at the Patterson City Jail. Do you want to go and proceed with this hearing?
Huh?
Do you want to proceed with this hearing?
Do I want to proceed with the hearing?
Yes.
What does that mean?
It was a formality. I should have asked you this question prior to you answering all.
Prior to me having counsel?
Yeah.
Yes, sir. I'm protected by God. I'll proceed.
Okay, good. Mr. Prater, you can proceed.
Okay, thank you. Thank you. And I didn't, something was wrong with my computer and I didn't hear the introduction. That's why I was kind of taken by surprise. And so I didn't ask other questions either. So I appreciate you clearing that up. Let's see here, Mr. Gibbons, I'm looking to see your girlfriend. Now she's going to speak to us, right?
That's the question. Well, she unmuted herself. I can see that.
Okay, Miss Gant, talk to us about this incident.
Yes, sir. I had to end up sending in an email letter to y'all.
Okay, so you don't want to speak to it, you just want us to read the email.
If y'all need me to speak, I can speak.
Well, it's always better to have somebody to answer questions. Did he hit you?
We both was basically hitting one another.
Okay, did he hit you with something in a rag?
No, I did not state that. It was a lot because I know the system down there, they don't like him. So with the person who called in the anonymous call, see, I just wanted him to leave the house basically so he can calm down. I didn't want to go press charges or any of that. Like I told him, I wasn't going to do none of that. I just wanted him to leave the home.
Did he hit you with something in a rag?
No, sir.
So the police found a rag wrapped up, a tire iron wrapped up in a rag, just like you had said.
They wanted to search my vehicle for whatever reason. So I just let them search it, and whatever they found in there, that's what they had.
Has the police ever been called to y'all's house before?
No, because we don't get into it like that.
Have the police ever been called on y'all fighting before?
No, that was the first incident.
Does he have a protective order against you now?
Do he have one against me?
Excuse me. Do you have one against him? I said that wrong.
Oh, no, sir. I didn't file for anything. I didn't go to court. I didn't press charges. I didn't do any of that.
But did the court issue a protective order?
I'm not sure. I didn't get one. I didn't go to court or anything, and I didn't get one.
We have evidence that it did. So.
But can you tell me what address they sent it to? Because I didn't receive it.
We don't have that address. That's between the court, but it just says in the sentence that he had served 101 days plus a protective order. Are y'all still boyfriend, girlfriend?
Yes.
I don't know how that can happen with a protective order. Okay. Your full-time date, Mr. Gibbons, your full-time date is in less than a year, but right at a year. Is that correct?
Yes, sir. I believe so. Yes, sir. I think it's August 7th of next year. I want to say, if I'm not mistaken.
Well, what I'm thinking is that, okay, I'm thinking I'm ready to vote, but I'll turn it over to my fellow board members for any questions they have.
Ms. Ledoux, do you have any questions?
Well, I'm just very concerned because I am looking at order of protection issued in St. Mary on May of 2026, and the date that this order is in should be adhered to is in May of 28. So actually, according to this protective order, there should be no communication between Ms. Gant and Mr. Gibbons even now. And there would not be any contact unless the court rescinded this until 2028. So I believe that there's, we're in violation right now, them being communicated, but I don't have any other questions. I'm just concerned about that. Thank you.
Ms. Grant, are you afraid of him?
Sir, can you repeat that?
Are you afraid of your boyfriend?
No, sir.
And you say this is the first time this has happened?
Yes, sir.
Do you guys plan to live together or still see each other?
We have kids together.
You have plans to live together or what?
I guess he don't have nowhere else to go. If he get out, where he gonna go? I'm the only one with a stable place.
Okay. Mr. Prater, are you ready to vote?
Yes, sir, I am. Okay, my vote is, and I just have one of 3 votes, but I think that you would be well served, and I think that your relationship with your girlfriend seems to be somewhat volatile, and I think it'd be best served for you to spend some time in work release. I think this is the ideal situation for a work release. You had you a job, you make you some money, you be separate from her, you'll have time to continue your growth that you have experienced this time. And so my vote is that you be transferred to a DLC facility and you complete the rest of your sentence for the rest of the year in a work release situation.
Okay, thank you. Ms. Ledoux?
we'd prefer to see that work release have some type of domestic abuse prevention training as well, because I believe that that's the genesis of your issue, is that you don't know how to treat women. But I'll concur, and I'll add that as an option as well. So I
Okay.
vote to revoke, in lieu of revocation, transitional work program with potential of domestic protective intervention training.
Thank you so much. And I concur with my colleagues. Mr. Givens, that concludes ours. You have been revoked, and in lieu of revocation, bill will be put on work release. And this ends our work here today.
It's TCF Live, Hour 3 on a Wednesday. The greatest LawTube morning show. The best, no better. At least that's what I've been told. Alrighty. Keeping with this channel's promise of 9 to 11% more, Judge Boyd, let's go to San Antonio.
And are you Mr. Ortega?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Ortega, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. State moves to waive and abandon the punishment enhancement allegation.
No objection.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate
Yes.
places? You're charged with evading arrest, detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Ortega, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 2 years in the prison. There is a $600 fine and there are no applications. Did you understand that as your plea?
Yes, Your Honor.
State defense?
Yes, Your Honor.
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
No objection.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
We're asking the court to file the plea bargain.
All right. Who is Danielle Butcher to you?
She was ex-girlfriend when.
All righty. The court will find you guilty. The court will sentence you to 2 years in prison. Give you credit for any time served. There's to be no contact with Danielle Nicole Butcher. There's to be no unsupervised contact with minors. There's a $600 fine. Time and money will run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right. How old are you?
I'm 35, man.
Do you want to spend the rest of your life in prison?
No, man, but sadly, I did make mistakes in my life. I was in the process of getting my life in order this recent time. I held a job for about almost 24 months. It was at Sonic. The Sonic got closed down, and that's kind of where I started wavering down a little bit.
But here's the thing. These
no
are not
excuses.
mistakes, though.
Yes, ma'am.
These are choices.
Yes,
You
ma'am.
can say you made bad choices in your life.
I was.
So when are you going to start making the correct choices? Because otherwise, you know what's going to end up happening to you? And you're at an age where the years start flying by. Next thing you know, birthday is here.
Yes, ma'am.
And you're another year older.
Yes, ma'am.
If you don't start changing, you're going to spend the rest of your life in prison. And I'm going to tell you what I told people before. Guess what? At the prison, if they say, you know what, this cell or this prison can only hold, hypothetically, let's say they say we can only hold 20,000 people. If we get more than $20,000, if it's just one extra person, we won't be able to fit them in here. It's a fire hazard. It's inhumane. Guess what they're going to say? Well, this one person needs to be in prison. They're going to find a place for you at the prison. It always happens. And there is no politician who will come out and stand up and say, you know what? There's too much overcrowding. Let's make this more humane. You know why they don't do that? Because citizens who have never toured the prison, never toured the jail, you know what they say? It's not supposed to be a Holiday Inn. It's not supposed to be a picnic. People are supposed to suffer at the jail and at the prison because they did wrong. So if you continue on this vein, you're going to spend the rest of your life in somebody's prison.
I understand.
Don't be that person, okay?
Okay, thank you. God
All
bless you.
right, good luck to you, okay?
you.
And
God
take
bless you.
advantage of whatever they're offering there, okay?
Yes, sir.
All righty, if y'all can put the other inmate on hold. Okay.
All right, well, they put the other inmate on hold. Where was this back in the chat? Oh, Great Granny. In my opinion, just because you're legally sane doesn't necessarily mean you're sane. You just look at me, I'm nuttier than a fruitcake. First of all, funny, Gigi, and welcome back. We've missed you. But that was a perfect lead in to second session today, 2:30 p.m. Eastern, 11:30 a.m. Pacific. Do join us for that show because the lead case in the lineup today for second session is a case where they are considering an insanity plea. So do check that out. Do join us for that show. Let's go back to the board. Try them again. New contestant.
Good morning. My name is Chuck Tillis. I'm serving as chair for this committee this morning. My colleagues are on Zoom. Ms. Ledoux, Jerry Ledoux, and Mr. Steve Prater. We're at the Louisiana State Penitentiary this morning. Would you state your name and DLC number for the record, please?
Philip Shane, 91217.
The staff there introduce themselves.
Deputy Warden Rochelle Ambo.
Reginald Admiral, classification.
Warren Shipley, inmate records. Jody Sargent, program consultant.
Thank you so much. Mr. Phillips, Mr. Prater is handling your case today. I guess he will ask later for the visitors there to introduce themselves, but I'm going to let Mr. Prater go ahead and start his interview, please.
Okay, Mr. Shane, is that the way you say it?
Yes, sir.
Okay. Well, good morning to you.
Morning.
I know this is a exciting time for you, but it's also a very nervous time for you. A lot on the line here. and we'll
Yeah.
try to make it as easy as possible. I've got quite a few questions, and I would imagine that my cohorts on the board have some questions for you later. But before we get into that, I'd like to hear what your side, what you did, why you did it, what you've been doing since you got caught and sentenced to jail, which has been 44 years ago, the one, if my math is correct. Then I want to hear from the warden what he's got to say. And then we'll ask some questions after we talk to some of your supporters and some of those in opposition. So to start off with, it's your day, and you'll have a chance to answer some questions later too. So this isn't the only time you'll have an opportunity to say something, but now's a good place to start. So tell us a little bit about yourself.
Okay, as you said, I've been incarcerated for 47 years. Before I really get into anything, I'd like to begin by thanking y'all for giving me the opportunity today. If it's permissible, I'd like to apologize to the Fowles family ahead of this hearing. I can't even imagine how difficult it is for them to have to go through this. You know, the crime itself is, I know that I'm going to be asked a lot about that, which is understandable. And it's, you know, something obviously when you're preparing for a hearing like this, is something that you think about even more than you ordinarily do. But as far as the crime is concerned, earlier in the week prior to the crime, my mother and I had met with my parole officer. And my parole officer had asked my mother if I'd been coming home on time for curfew. And when she told him no, he told her that the next time that I was late for curfew, she needed to call him and let him know, because that type of behavior needed to be corrected. And the next time I was late, that he was going to send me back to reform school. So the night of the crime, prior to leaving the house that night, I was going through the drawers of my mother's bedroom looking for a prescription medication. At that time, I had become so addicted to drugs that, as far as pills were concerned, I didn't care what they were. I would take whatever as long as it got me high. While I was going through her drawers searching for pills, I found a .22 caliber revolver that my Uncle Earl, who's a Texas Ranger, had given to my mother when we vacationed there the week earlier. And I pulled it and a box of shells out of the drawer, put them in my jacket pocket, and headed out for the night. Every Friday night, my friends and I would meet up at Happy Days Drive-In. And even though all of us were underage, a lot of us were allowed to purchase alcohol. So that's what we did that night. We spent several hours drinking, smoking weed, and popping pills is what I was doing. But a lot happened that night. But just to get to the details of the crime itself, which, you know, understandably, I hate even talking about it, but I know that it's necessary. I'd asked somebody what time it was. They told me it was 11:30. It was already 30 minutes past my curfew. So I headed home. I took the shortcut to my house, which was to cut through a vacant field. And as I was coming out of the field, it's a four-way stop right there. I saw some lights coming down the street. And thinking that it might be a police car patrolling the neighborhood, I ducked under a carport and hid behind a car. And when I did this, the back door opened, and Miss Faust asked, I could heard Miss Faust ask, "Who's there?" Well, when I heard that, I, tried to ease to the front of the car where I could, ease on off. But Miss Faust, who had taught me in elementary school, called me by name and said, "You're the one that's been breaking into my house. I'm going to call the police." Well, when she mentioned calling the police, I panicked. I was like, I could not go back to reform school, and that's all I was thinking. I'm in trouble. So I tried to talk her out of calling the police. when I was, just to take a step back, when I was in reform school, and the reason that this was so harrowing is because the time that I had in reform school was very bad, almost daily basis. I had to fight. And in the end, not even that saved me, because one night I got up late to use the bathroom. I was standing at the urinal. I got knocked behind the head. I was knocked out, and I was sexually assaulted. So I did not want to go back to reform school. So when Miss Faust went back in the house, I was trying to talk her out of calling the police. We had a confrontation by the phone. She ran for the front door. When she did, you know, it's like I wasn't even thinking. I panicked. I pulled the pistol out of my pocket. I pointed it in her direction. I closed my eyes and I pulled the trigger. And how many times I pulled the trigger, I don't know. All I know is that I pulled it again and again and again. It's, you know, it is obvious, but I need to say this. Ms. Faust did not deserve what I did to her. Her family doesn't deserve to have to live without their mother. But when we were in the house, Ms. Faust was trying to say something. So I went over to her. I knelt down on the side of her and I leaned over to where I could hear. And she told me that she was sorry and for me to take whatever I wanted. I didn't even have the courage to look at her. I said out loud, I didn't want anything. I was just trying to go home. And I got up and I went to the phone. I was going to try and call for help, but I knew that it was too late. I took Miss Faust's purse and her car keys off of the kitchen table, and I left in her car. I drove to New Orleans, a place that I had never been in my life, and I spent that weekend drinking and taking pills and drugging, everything in an effort to try and erase or forget what I had done. That Sunday night, I drove back to New Iberia. I parked the car a few blocks from my house, and I went home. The next morning, I got up, I went to work. I was arrested later that afternoon, and when we got to the police station, I told them everything that had happened. But
Okay, but let's fast forward and we'll ask some more questions about that and about some other things. But what about your activities since you've been locked up?
I came as a I came as a 16-year-old kid, and the first 10 years of my life, you've been in law enforcement your whole life, so you know that things have changed, and here they've changed dramatically. Back at the time when I first came here, Angola was referred to as the bloodiest prison in the nation. And, you know, I fell in with a crowd of people that I felt safe with, but the people that I was safe with, unfortunately, were drug dealers. They ran a card game. So they all used heroin, which is something that I had never used. I began using heroin. So I used drugs, I dealt drugs. And as sad as it is to say, the first 10 years of my time in Angola just went by like a blur. I was in a drug addicted state that entire time. I was sitting on the yard one day with a couple of my friends, and we were smoking a weed. We were smoking a weed, a joint, passing it around. And one of my friends asked, you know, he said, "Aren't y'all tired of doing this, the same thing day after day?" And I was. And I told him, I said, "Yeah." I said, "I am. Why?" And he said, well, he said, the AA group that they have here, their leadership is having problems. And I'm thinking about running for that office and getting in there, and then we'll have a club that we can go to. So we ended up doing that. We got the sober group of Alcoholics Anonymous. And when I began attending AA, I used to sit in the back of the room and look at the speakers get behind the podium and share their stories. And I thought it was kind of degrading that someone would get up there and share such, things about themselves. I didn't know how they did it. I wasn't serious about the program. I was still drugging at that time. One day, a lady got up behind the podium, acknowledged being a heroin addict, and started telling a story. And it's like the story that she told, I could relate to. It's like she was sharing some of my story. And her story had an impact on me. When she got down from the podium, I went to the table. Her and her husband were there, and I sat down. I asked her a few questions. We started talking. And her husband ended up becoming my sponsor in AA. I got serious about AA. I got serious about wanting to be clean. And I've been a part of AA ever since then. I've been clean for 21 years. I'd like to say that, from that time on, I've never had a hiccup. I've never had a bump. I've never had a write-up. Unfortunately, that's not true. And despite I was in the Bible college, I graduated from the Bible college. Shortly before graduating the Bible college, the director of the Bible college and I had an issue about the ministry. I was carrying a small Bible to the transition unit. He wanted me to carry a big Bible. And I like I told him, if the people that I go and minister to over there can't see that I'm a Christian by my activities, then I'm doing something wrong. We ended up having a disagreement about that. And long story short, I got out of the ministry. I went to the farm office to work for the farm manager. And 2000, I had been diagnosed with hepatitis C. I went through treatment one time. I ended up, after 4 months, I had to get off of treatment. I lost a lot of weight, couldn't eat, couldn't sleep. When my blood was tested, my ALT levels were so high, they talked me into getting back on treatment. I tried it again. I ended up having to get off of treatment again for the same reason. About 6 months later, when I was tested, I was told by the liver specialist that my liver was being attacked, that I was going to develop cirrhosis of the liver, and that I was dying. And I asked him how long he was talking about, and he told me it could be a couple months, it could be a year. They weren't sure. So when I got back to the farm office, the only thing I was thinking is that, and one of the biggest fears that all prisoners have is of dying in prison. And I didn't want to die in prison, so I escaped. I stayed gone for a couple of hours. I was brought back to Angola. Warden Kane and Warden Van Noy went to Natchez, Mississippi, and picked me up and brought me back. I spent 15 years in solitary confinement as a result of that escape. Having been raised in a dysfunctional home by a severely abusive father, when I was a kid, I was locked in closets and things like that. I developed claustrophobia. So being in a cell, a single man cell, was extremely hard to try and adapt to. I thought I was doing a pretty good job. We were transferred to Hunt. They opened a CCR tier at Hunt. And when I got there, a group of people were talking about escaping. At the same time, the juvenile issue, Miller and Graham, had just come out. So I had a realistic opportunity of getting out. When they asked me about escaping, I told them there was no way I was gonna, get out of prison. And I ended up ultimately, at the end of the day, I ended up participating in the escape. I've told people forever, that's not something that I wanted to be a part of, and that is absolutely true. But what is even more true than that is the fact that I did cut 2 bars out of my cell. I participated in that escape. I'm as guilty as they are for having done it. We didn't even get out off the tier. They returned us to Angola. I was put back on a CCR tier, and I met a classification officer named Miss Amber Victorio. And Miss Amber and I, would just conduct business and talk. She was a very nice person. And she ended up going to Warden Van Noy in 17 and asked him to let me off of CCR. First time she did that, he laughed at her. There's no way I'm letting him out of CCR. She went back to him again, a few months later. And it was like he said, okay, I'm gonna give him a chance. I'm gonna let him out. They came to Camp J, him, the Deputy Warden Lamartinaire, the Warden of Security Benjamin, came and talked to me at Camp J, told me they would send me to the CCR dorm. And I was released from the cell. I got in the dorm. They had class activities. I started participating in the classes. When I was a kid, I quit school because I felt
let me stop you there for just a second. Let's get into that in a little bit. Let's continue your trek. Kind of speed it up a little bit for us. What you're saying is extremely interesting to me. It'd be a really good documentary. But I'm sorry to say we don't have the amount of time that we do for a documentary. So continue with your trek through your prison life there.
Okay, sir. I can pretty much sum everything up just by saying this. When in the CCR, when I started taking these classes, and I realized that I actually could learn, I realized that I was good at this, that I could help other inmates. I started doing that. The administration and the lady that I worked for, Miss Jody, gave me a chance. They made me a social mentor. I began facilitating classes. As of today, I've taken all of the classes in Angola. I have facilitated all of the life skill classes. And I presently facilitate victim awareness and celebrate recovery. So that's.
Yes, you got it. I've read through your entire file about Paul's and being a volunteer in the Paul's program and all of the different things, the letters from Warden Kane and the other wardens and the different things. But now I'd like to hear what the warden there at the prison says.
Good morning, Mr. Prater. How you doing?
I'm doing good.
Okay, so Philip Shane is a minimum A offender. He assigned to MAG 2 and he works as a mentor along with the PAWS program where he trained dogs to become service dogs for veterans. He's a graduate of the Baptist, New Orleans Baptist Theological Seminary. He completed TAPUCO, his 100-hour pre-release Inside Out DAS, T4C, substance abuse, victim awareness and letter training, more accomplished, and he has a low tiger. He also completes any task that you give him on time. He has a positive work ethics. And he cooperates with staff when staff give him instructions. Since I've been here 4 years, going on 5 years, I've been here. Philip Shane has shown me nothing that speaks nothing about change. I mean, nothing but he has changed. I have not seen anything that I heard in the previous past about Philip. Everything has been positive with Philip. And I think Philip probably is ready to go home after 44 years.
Okay. All right, thank you, Warden. We appreciate that and value your input also. Well, let's move on now, and we're going to talk to two people that are in support. One is a friend of yours, Mr. Kyle Abear, if I'm saying that correctly, and then we'll hear from Andrew Hunley with Louisiana Parole Project. So, Kyle, would you start us off, and Mr. Hunley, would you finish us up?
I'd be honored, Mr. Prater. Great morning. My name is Kyle Abear, and I'm a former incarcerate at the Louisiana State Penitentiary, where I served 22 and a half years, and it's only by God's grace I made parole in December of 21. So I've been home 4 years. And like Philip, I'm a graduate of the New Orleans Baptist Theological Seminary. I completed my master's program while incarcerated and got my doctorate since I've been home. Today, I am a supervisor here at Deltac Manufacturers. I run the laser shop, shipping, as well as quality control, and I am the reentry chaplain at the Livingston Parish Detention Center. Like Philip, I had a very shady and just a horrible former life after going, through prison. Prison became a mercy, and going through the seminary, and my faith was instilled. I was changed man, and I got to spend a lot of time with Philip. I met him in 2000. I was entering the seminary at that time, so it was during the time of the hepatitis. I got to see him go through that, and I watched him go through his struggles after the escape, and he came back to the prison and was at CCR being the inmate minister. I had access to all the lockdown areas as well as the dorms. Got to spend a lot of quality time with Philip, and now that I'm home, I go to the rodeo. I haven't missed a rodeo. As a matter of fact, I open up every rodeo in prayer. And I get to spend time with Philip. I was part of the PAUSE program. And also upon release, like Philip, he's going to be going to the Parole Project, which I did 6 months. And it was just a blessing. But I've watched Philip go from a very troubled individual to one who is remorseful, one who would definitely be a asset to the community. And Mr. Prater, I know the decision of this board is weighty, and I never want to demise or overstep the victim. I am in full respect of the victim, and I'm sorry, so sorry that this happened. And I'm just here to give you my heart of what I have witnessed firsthand with Philip Shane. And look, I'm open for questions. My life is an open book, but I'm in full support of Philip. And it has nothing to do with how much time that he has served, because there's no time in the world that can replace the crime that he committed. But I will say this, he's not the man that he was before. And I'm truly proud of him. I love Philip, and I'm grateful for him. But you can ask me any questions, sir.
Well, I don't think I have any, but you were very succinct and very convincing in what you had to say, and I appreciate that, and I congratulate you on your work now and what
Yes,
you
sir.
accomplished throughout.
Thank you, sir.
Do any board members have any questions? Okay, well, we'll move on to Mr. Hunley then. Mr. Hunley, would you wrap it up for the supporters, please, and tell us what you offer in your program?
Certainly. Good morning, Andrew Hunley with Louisiana Parole Project, appearing today to confirm to the board that our organization continues to stand by Philip. We've been involved with this process with Philip since his first parole hearing, and then before that, whenever he was being considered for resentencing in court a few years back. Not to belabor the record that is already in front of you, and not to repeat things I'm sure that his attorney will also say, but we have a great deal of confidence in Philip's ability to be successful if he's given parole, based on our appreciation of the totality of his record. I think Philip's story can be told in at least a couple chapters, and not to minimize the earlier time in his life and the earlier time in his incarceration, But for the last couple decades, Philip's record of rehabilitation, in our opinion, is very evident. I think the thing that we are amongst the things we're most impressed about is that he's an active member inside of his community, even when compared to individuals inside Angola who provide community service. He is someone who goes above and beyond, especially with his commitment to the PAWS program and his ongoing long-term commitment for many people. It's an easy program to burn out on. And he's continued for several years to be involved and is recognized by staff and his peers as a leader in that program. And that tells us that he can do something, he can stick with it even whenever things get tough. He, as you see, has an excellent record of rehabilitation, and he continues to be involved in self-help programming. I think what we see sometimes is people go through the programming, check all the boxes, and okay, I've done everything that the prison has to offer. I think in his case, he has continued and even today is enrolled in programming that he could tell the board, I've done that years ago, but he continues that work. I think that at this point, at 63 years old, Philip's very employable. I know the board's aware that Commissioner Kane has offered Philip a job at Parchman. What we would say to the board is that it seems as this is sort of a sweet spot in our opinion, that if he were to be granted parole release in the near future, that he's employable today, which may not be the case 5 years from now or later into the future. The parole project stands by Philip and offers the totality of our reentry program, which the board's very aware of. This parole board over almost the last decade has paroled over 100 juvenile lifers. Virtually all of them have come through our program. So we have a lot of experience in the reentry of someone who went to prison as a teenager and has served decades there. So in that instance, we're very confident in our ability and Philip's ability to abide by the program rules. The specific suggestion we would make in Philip's situation is that if he's granted parole, that he be granted to us to complete phase 1 of our program, and then to immediately be relocated to his Mississippi ICOTS to work at Parchman Prison. It's a very unique setup because generally people don't parole from one penitentiary to go work and live at another penitentiary. I think that what the board and the community could be confident in is that it would create an exceptional level of accountability around Philip for him to work at Parchman, where he would have a community of support, but also if he strayed from expectations, it would become evident. So parole projects would be more than willing for Philip to be a long-term resident in our program, but because of that opportunity at Parchman, we would suggest a short stay with us, then a ICOTS transfer to Mississippi. And if the board would have any other questions about his reentry plan, we would stand ready to answer those. Thank you.
Okay, Mr. Hunley, we appreciate you and appreciate the work that your organization does under your leadership, and we appreciate that. And let's see, my board members have any questions for Mr. Hunley? Okay, well, we'll move on to those that are in opposition, and we will.
Mr. Prater,
Yes.
Prater, we're gonna hear from the attorney, his attorney.
Okay, I do not show him on my board, and he's not listed in the those that are speaking, so I had no idea he was here.
Privilege and pleasure to represent Philip Shane before this board this morning. I have represented Philip Shane for over 8 years, and over that time, I've gotten to know him fairly well. And I can tell you, as have his supporters, that Philip is a leader, the mentor, and facilitator of multiple classes, including the victim awareness class. I can tell you about his dedicated faith journey, his early graduation from Bible college, and the endless hours he's been with the PAWS program, training service dogs for injured veterans. I can tell you about his decades-long maintenance of sobriety, participation multiple times of every class available to him, his low Tiger score, his status as a Class A trustee, which is the most trusted status that an inmate can earn in Angola. And I imagine, when I try to put myself in your shoes, that one of the hardest parts of your position must be to try and discern whether the limited interaction that you have with him and the limited interaction that you have with those in opposition and the victim, that it is really difficult to discern whether or not you're developing an accurate picture of who this person truly is, whether they've grown, whether they've matured, whether they are genuinely remorseful, whether they've absorbed the information that they've received in all of these classes, or whether they are just ticking boxes. And I will say that in this case, what you have before you is the testimony, statements, recommendations from a bevy of experts in this field who are all in support of Philip. You can rely on those opinions because those are people that have known Philip for decades, that have spent 24/7 time with him in a prison setting, where if you have anger issues, where if you are deceptive, where if you are manipulative, those traits are going to show themselves in a prison setting, and people are going to be aware of them because you are being observed for 24 hours a day. And the expert that have seen his struggles, his history with those escapes, and also his triumphs over his lifetime, they can tell you that Philip has truly been rehabilitated. Dr. John Simino, who's a highly respected psychologist in the field and whose report was included in your materials, he's regularly used by the state. He evaluated Philip for multiple hours, gave him a host of psychological testing, beginning in 2019. And he stated in his report, I was particularly impressed that Mr. Shane seems to have found meaning, purpose, and passion for some of his work at Angola. He was honest in talking about the crime, as well as his escape and escape attempt, taking full responsibility for his poor decision-making in the past. He expresses severe remorse, appears to have developed a meaningful conscience. It does appear that Mr. Shane is not only capable of change for the better, but he has changed. The arrogance and manipulative nature of his behaviors that was noted in previous hearings was simply not evident during my extensive interviews with Mr. Shane or in any of the psychological test results. Jody Sturgeon, who's a transition specialist at Angola, who has known Philip for many years, who testified at his Miller hearing and testified that she had never testified in support of any other person serving time at Angola. She taught Philip victim awareness, and then she co-taught the class with him. She said, to me, Philip shows the epitome of remorse. He shows compassion for others. To me, he's truly remorseful for what he's done. And he just wants to give back in a way that shows he knows he made a mistake. He wants to do whatever is necessary, what he can do within his powers to just help others, and to teach others not to do what he did, so no one else ends up in the predicament that he did as a 16-year-old child. Again, I know that you've seen these, but Daryl Benoit, who's a warden at Angola, who has known Philip for over 40 years. In fact, they both started at Angola at the same time. He wrote in a letter, Philip must have arrived as an inmate at the prison around the same time I started working there 40 years ago. We were both very young then. Over the years, we basically grew up together. I have witnessed Philip mature, change, and improve himself across the years I have known him. From the time he came to Angola as a teenager to today, Philip has totally turned his life around. And I don't mean to emphasize his disciplinary record and the escapes that are on there, but I know that they have been a concern to the board in the past. I know that they are a concern to the family. And Warden Benoit, who picked Philip Shane up after his first escape attempt, was there when he attempted the second time, has said, as a prison, we take escape seriously. However, I do not believe Philip's escape attempt and write-up for attempted escape should disqualify him from the opportunity for a second chance. And I do not believe that his escape needs would not do well in society if released. Philip's escape was wrong, but it does not tell me that he has not been rehabilitated, especially considering what he has accomplished since then. Philip's overall prison record is that of someone who has been a model inmate for the majority of his 43 years of incarceration. Again, Warden Kane, who is the former warden of Angola and is now the Commissioner of Corrections in Mississippi, has invited Philip to work among the hand-picked cohort of lifers he employs as chaplain at Parchment Prison. He wrote, "I also am a strong believer in redemption and rehabilitation. Philip is a Class A trustee and working in the prison as a mentor and facilitator. I know that he is using the skills he learned during Bible college to help others. Prisons depend on people like Philip to learn from their mistakes, set a good example for other inmates, and teach inmates positive life skills. Philip is doing that good work. The LSP administrators and staff have restored their trust in Philip, and I have too. I am confident that the Department of Corrections has accomplished its purpose of correcting the deviant behavior and preparing Philip for release into society. His continued incarceration would be for punishment and not for rehabilitation. The experts that have known Philip Shane for decades have had the chance to observe him for 24 hours a day, 7 days a week for the past 47 years, have observed him when no one was watching, where if you have issues, they are going to manifest themselves. The experts without reservation say that Philip has changed, that he's matured, that he's rehabilitated. Philip has a solid re-entry plan, and we have no false illusions about how difficult the transition back into society is. However, he has also taken that next step very seriously, where he's put into place a very structured environment where he would go to the Louisiana Parole Project, he would continue maintaining his sobriety, he would continue working on himself the way he has dedicated himself to in the past decade or more. I really appreciate your time. I know that we've been long-winded, all of us, and so thank you so much for your patience and for considering Philip Shane's record.
Thank you so much.
Thank
you.
you.
I have a question, excuse me. May I ask a question? In Exhibit 1 of the 256-page document we were provided, the letter from Warden Kane, Commissioner Kane, is dated July 10th, 2023. Do we have an update to that? Is that still a valid offer of employment?
Thank you. It is still a valid offer of employment. I believe that we included an updated letter from Warden Kane. It would have been signed, I believe, in June of this year. And he did renew his support of Philip. Since he wrote that letter in 2023, Philip has only continued to strive and continued to earn the trust of everyone around him and earn more certificates. So he does still have that offer open to him.
Okay, great. Thank you.
Are we going to allow the guests to speak?
Okay. We appreciate that. Okay, we'll move on to I've refreshed my screen now, and I have two more people that will be speaking. Now they won't be speaking, but Ashley, who is a legal member, is also in support. And Lori Dorsey is the sister who will not be speaking, but is also in support. Okay, we'll move on to those now that will be speaking in opposition. Okay, the first one, we'll save the last for the assistant district attorney. The first person, according to my list, that will be speaking will be on Zoom, Miss Nancy Marino. Miss Marino, are you on Zoom with us?
No.
Yeah, you can stand right on there, please.
Is that?
I can talk.
Yes.
I want to talk a minute about my mother. She was a teacher. She attended Dominican College during the Depression teaching. Her first teaching job was at Louisiana. She married and had 6 children. One thing she always taught us was always do the right thing. And you know what it is. This is that she taught all of us this. And prior to working with the parole project, we never heard any "I'm sorry," nothing, no remorse, no apology. At a hearing in New Iberia, we had to listen to the very long saga of everything he'd ever done with an excuse for everything. There was no accountability. When his plea was rejected, by Judge DeMaia, he acted out, beating his fist on the table. And my question is, can he change? Can he control his emotions? Or is he just walking the walk, talking? Or is he just saying what he thinks we want to hear?
Okay.
I ask you to please honor my mother. And do.
Thank you so much.
Okay, well, we appreciate those words. Let's move on now to headquarters. I think there are 3 people at headquarters, according to the information I have, that will be speaking. Miss Caroline Davis.
Good morning. Dear members of the board, my name is Caroline Davis. I'm the granddaughter of Laura Faust, the woman that Philip Shane murdered November the 2nd, 1979. I appreciate the opportunity to share the perspective of a family that has been living with the consequences of this crime for nearly 5 decades. I've listened to the parole hearing and I understand that Mr. Shane has spent many years participating in rehabilitation programs, earning educational achievements, mentoring others, and somewhat expressing remorse today. I do not discount that people can change. However, this hearing is not only about Mr. Shane, who he is today. It's also about what was permanently taken from my family. My grandmother was brutally shot and murdered. He ended her life in terror inside of her own home. She never had the opportunity to grow old, to enjoy retirement, to watch her grandchildren, for us to grow up, to celebrate birthdays, holidays, weddings, and the countless moments that make up a family's life. I was robbed of the chance to know my grandmother, have one memory. Every other memory that I have is that from the day she was stolen from us, November the 2nd, 1979. The greatest victim in this case has no voice before this board today.
My mother lost her mother. This loss changed her forever. It changed our family forever. Trauma like this does not end after 5 years, 10 years, 47 years. It becomes part of a generation, and every generation follows. Ironically, Mr. Shane himself has acknowledged during his victim awareness training that the pain experienced by a victim's family lasts a lifetime. He's absolutely correct. My family is living proof of that. While I recognize his accomplishments while incarcerated, rehabilitation alone cannot erase the devastation and the irreversible consequences of his crime. I was also struck by the concerns expressed by the district attorney and the members of this board regarding the history of his escapes attempts and the repeated patterns of making dangerous decisions when confronted with adversity. Those incidents occurred years after his conviction and well into him being an adult and being an adulthood. The board members themselves concluded that more time was necessary to demonstrate sustained judgment and public safety. And I respectfully agree with those concerns and still have those concerns. Parole is not simply recognition of rehabilitation. It is a determination that releasing an individual is appropriate in light of the crime committed, the interest of justice, the safety of the public, and the impact of the victim. For my family, justice has never been restored because justice cannot restore life. Nothing can give our grandmother back to us. Nothing can give my mother back her mother. Nothing can give back the years that my mother should have had with her own mother. Nothing can give my grandmother, nothing can give me the grandmother that I never got to know. Mr. Shane has lived for more than 47 years after taking my grandmother's life. He has had the opportunity to grow and learn, build relationships, discover faith, and envision the future. My grandmother was denied every one of those opportunities. As you consider this request for parole, I ask that you remember not only the man standing before you today, or sitting before you today, but also the woman whose life was ended because of his actions, and the family that continues to bear this loss every single day. On behalf of my family and in memory of my grandmother, Laura Faust, I respectfully ask that you deny parole. Thank you for your time and consideration, and for remembering victims whose lives cannot be restored. Respectfully, Caroline Davis.
Thank you.
All right, we appreciate that. Let's see, we'll now hear from Miss Amy Rodenberg. Miss Rodenberg, are you available?
She's not going to speak. Mrs. Prater, she's not going to speak.
She's here in support of the denial.
Claire, do you want to go ahead?
Good morning. My name is Claire Howington. I'm here with the 16th District Attorney's Office, and I'm here to oppose Mr. Shane's release on parole. I've been here before. I've been with this case since 2016, so I am very aware of the facts of this case. And look, I'm not going to spend a whole lot of time going over those. You've heard from Mr. Shane, and I think what you heard from Miss Nancy and Miss Caroline are very powerful, and they also sum up most of my thoughts about this matter too. So I don't need to repeat all of those, but I do want to highlight one of the things that when you think about this case, and it has always been something that I have tried to figure out why I'm so vehemently opposed to Mr. Shane being released on parole. And I was thinking about it, and one of the things that is really the hook for me is when we had this hearing in 2016, Mr. Shane got on the stand under oath And he gave essentially the same story that we heard today about what happened when he murdered his spouse. But then he came back later and he said that her last words were, "I forgive you." And I couldn't wrap my head around that because he had said previously that he went over to her and that she said, "I'm sorry, take what you wanted." He went to go call the police and he realized it was too late. So I couldn't fit those two things together. How does that timeline work out that it's too late, but she says, "I forgive you"? And the only conclusion that I could draw, and I hope this board draws that conclusion too, is that he lied about that. And I think the cruelty of lying about your loved one's last words in front of the family at that hearing, and to have them be, "I forgive you," is something that I personally don't think I will ever get past. And I think that it just goes to show, yes, that's been some time, but I don't think he will ever be truly rehabilitated if he can impose that kind of cruelty on people who have already had their mother taken away from them. So for those reasons, I ask you to consider their comments and then deny parole.
Thank you. Mr. Prater.
Okay, thank you. All right, now we will hear from the DA's office, Miss Clave Havington.
She just went, sir. Let's move into the interview process.
Okay, well, my computer is, anyway, we won't get into all that. Okay, there were some things, Mr. Shane, that I think were very interesting that we need to discuss. Number one, I'm kind of uncomfortable with this the last escape attempt. Would you go over that again for me, please?
In 2009, we were at Hunt Correctional Center. I was still in CCR. Three guys asked me actually two guys asked me if I wanted to escape. I told them no. And as a result of that, they asked someone else who said yes. The way that the cells were set up, one guy was in cell 4, one guy was in cell 5, I was in cell 6, and the other guy was in cell 7. So the guy in cell 7, he and I were talking. He said, "Look, I know you're not going to go, but if you're not going to go with us, you need to get out of that cell, or you're going to go back there. You're going to get in trouble just like we are." And I asked Lieutenant Johnson, who's the supervisor, to move me to another cell, and he said he wasn't moving anybody at that time. When on the review board, I asked to be moved. I wasn't moved, just in frustration and really not thinking. I mean, I'm in a cell. I'm claustrophobic. I'm thinking in terms of I'm getting ready to go back to Angola for something that I didn't even do. I just, okay, I'm gonna go. So I got a hacksaw blade from one of them. I cut a couple of the bars. And that was in 2009.
Yes, sir. And
that was, Mr. Prater, if I may, that the reason, if you look at my record, my disciplinary record, that's the last write-up that I had. And that's not by coincidence. The reason that that's the last write-up that I had is because when I sat in administrative segregation with a write-up for attempted escape coming back to Angola, I had to stop and ask myself, what did I do? Why did I do this? What am I trying to run from? Because I'm not the type of person, I've watched enough TV to know when people escape, you always have somebody coming after you. You have to live looking over your shoulder. That's not the way that I've ever wanted to live. So why was I trying to escape? And I came to the conclusion when I got back into my Christian faith, I came to the conclusion that I wasn't trying to escape from prison. I never tried to escape from prison. I was trying to escape from myself. I did not like myself. I didn't like who I was. I didn't know how to change it. But I have changed who I am now. And that's why that happened, sir.
That's understandable. And okay. What about my other board members? Do y'all have any questions?
Ms. Ledoux, do you have any?
You know, as I mentioned earlier, there are 256 pages just in one of the 6 documents that we have reviewed. I've had all my questions answered at this time. Did Warden Vanoy know you were going to be coming up for parole today?
Yes, he did. We had 2 different things going on, so he attended one and I attended this.
So, okay. So he was aware of that. Okay.
He was aware. Yes, he was.
Thank you very much. That's all.
Warden, when was the last write-up before he said the last write-up was 11/10. When was the last one after that?
On board is called to order. Today is Monday, June 22nd, 2026.
His last write-up was, the one before that was 10/28. Oh, it's the same date for 17.
Okay. All right.
And before that, it was 2020, 2003.
Before that was 2023
I see
before
it.
that, yeah, one in 2023 for 30C, and then the next one would be the first escape.
I see. I understand. Thank you. I wanted to introduce his guests there. Would they introduce themselves for the record?
Y'all too. Say your name.
I'm Ashley Cusick. I'm a member of Phillips' legal team.
I'm Lori Dorsey. I'm his baby sister.
Okay, thank you so much. Mr. Prater, are you ready to vote?
Yes, sir. I'm not really ready to because this is such a difficult case. But it is incumbent on me since it was my case and I studied it extensively and I've listened very carefully to all of the, I had 2 speakers going was what the problem was, and I apologize to the assistant district attorney for misidentifying her, but I did listen intently to everything that was said. And I'll just cut through the chase. I think Mr. Philip Shane has done an excellent job since he has straightened up his life. I think it took him quite a while to do that. I think he did some immature things even when he was when he was mature, when he had reached the age of maturity. I listened intently to the victims and the assistant district attorney and the supporters, in particular Mr. Hebert, I think what he had to say, and Mr. Hunley. And I read the letters from the other wardens, the previous wardens, and everything that's been said. And I still am not convinced that it's time for Mr. Shane to get out. Therefore, my vote is to deny his request for parole.
Ms. Ledoux.
As noted in the previous hearing, there was a need to see some additional years past his time of CCR. He has had 3 additional years, and those 3 years have been spent productively, in my opinion. I do believe that Mr. Shane has expressed remorse. At this time, I would grant conditional upon another 2 years of work within the facility. We have the ability to make our grant conditional upon additional resources. So I would like to see him continue his facilitation for another 2 years and then grant to the parole project.
Thank you. My vote today is going to be, I believe he's remorseful. He has done, kids do a lot of things that are stupid, in my opinion. I'm very sorry for the victims, and my vote today is going to be to grant also. But we need 3 votes to grant. So your vote today has been denied.
Alrighty, friends. Well, there you have it. In that case, it had to be unanimous. There was a question, does it have to be unanimous or majority? It depends on what's going on. For this particular type of hearing, it needed to be unanimous. So there you go. I hope you enjoyed overtime and enjoyed the day. I know I did. Thank you all for your support today, for sticking around, for engaging each other in the chat, for all of that. I now need to hustle because in 2 hours time we will be back for second session. Stick around. When we end the stream, it will send you over there so you can set a reminder, and I look forward to seeing you all then. In the meantime, go have yourselves a good day. We will see you soon. Take care. God bless.